time credit. Does that sound right to everybody? We do not have a holder from Montgomery County or Hamilton County. We established that as well. Mr. View, on behalf of the state.
Your Honor, I'm looking at Mr. Durham's history and lack of compliance in the case. I have concerns about whether or not he's taking probation seriously. The court probation have been offering him a number of opportunities to engage in treatment and services that are available to him. Certainly, if he's willing to do that, I understand why Officer Evans would want to continue working with him. But from my perspective, it looks like from his criminal history that he's not really motivated to do those things. And so my recommendation would be to terminate his probation, give him a local jail term of additional 180 days.
Officer Evans, anything from probation?
Yes, Your Honor. If Mr. Durham is wanting the help, the recommendation would be that he complete the Genesis program with sober living as aftercare and placed on an ankle monitor due to absconding from probation previously. He also has pending issues in Hamilton County for felony 3 drug possession.
Mr. Durham, we got door number 1, which is Genesis and monitor and sober living. Door number 2 is an additional 60 days in the county jail. Mr. Engel, where are we at on this?
I've explained those 2 options to him, Your Honor. I think he'd probably address the court. I think he is interested in working with the Genesis program and completing that if the court's willing to consider it.
What do you want to tell me, Mr. Durham?
I needed help.
Yes, you do. On that, we are all in agreement.
Yes, sir.
All right, court's going to continue on community control. I'm going to order that you enter into and successfully complete the Genesis program, plus be on electronically monitored supervision with a curfew for a period of 60 days after that. And we're going to move
to
court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation.
Yes,
While on community control, you also have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir, I do.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir, I do.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt or the jury's required to find you not guilty, their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. McKenna, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's called your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes, sir.
Now, you can also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or I would be required to find you not guilty. Do you understand that?
Yes, sir, I do.
Do you believe you understand each of these rights we've discussed?
Yes, sir, I do.
And you understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Tranter?
On or about the second day of November 2025, Warren County, State of Ohio, defendant did knowingly obtain, possess, or use a controlled substance, being methamphetamine, a Schedule II drug in an amount of 55 grams.
Mr. McKenna, anything on those facts?
She was in the car with the drugs, Judge. She acknowledges those facts.
Okay. Ms. Maines, you heard the statement that Ms. Tranter read.
Yes, sir.
You admit and acknowledge that what she said is true.
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What is your plea?
Guilty.
All right, the court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. And Ms. Maines, I'm not going to sentence you today. I don't know enough about you, although your name is familiar to me. Your mother's been before me before, correct?
Yes, sir.
Your fiance is currently before me, correct?
Mm-hmm.
Okay, he's in my Veterans Court, is
Yes,
that
sir.
right?
Yes, sir.
All right. I'm going to order pre-sentence investigation and a CBCF assessment, and we'll come back in a few weeks and do sentencing at that time. Mr. McKenna, you wish to be heard.
We asked to address bond today, Your Honor.
Go ahead.
Ms. Maines is 30 years old, Judge. She's single with no kids. She has no prior felonies. This is her first felony contact. She has been very polite and cooperative. She has a lot of anxiety. She's super stressed out about this. She definitely wants some drug help. She's asked me repeatedly to get out of jail, and she'd like another chance. She knows she screwed up last time.
Ms. Tranter, do you wish to be heard on bond?
Judge, the only thing I have on bond is if you do grant a reduction, we would ask for a monitor to be in place. And I know that there was discussion previously about having no contact, not only with the co-defendant, but obviously her fiance at this point as well. So
All right, Ms. Maines, I am going to reinstate your OR bond at this time with the condition that you be placed on electronically monitored house arrest.
Okay.
Now, it's very important that you understand and listen to me right now. I'm not looking for any response. This is my order. You understand, when I give an order, you have a sentencing coming up in about 6 to 8 weeks. At that sentencing, I'm going to decide whether or not you're going to be going to prison. Do you understand that?
Yes, sir.
Or even further incarceration in the county jail.
Yes, sir.
Now, if you don't want to go to prison, it's very important that you follow very closely the conditions of your bond. Do you understand?
Yes, sir.
So you're going to be placed on electronically monitored house arrest.
Okay.
You are not to use any drugs.
Yes, sir.
You're not to drink any alcohol, and you're not to smoke or use any marijuana or THC in any form. Do you understand that?
Yes, sir.
I understand you have been testing positive for marijuana. If you
Sure.
continue to test for marijuana, here's the problem with marijuana, is you have and I'm guessing, but based upon what Mr. McKenna has represented
Yes,
and
sir.
what I know about your family history, I'm guessing that you have a substance use disorder.
Yes, I do.
Okay,
Yes, I
so
do.
we can establish that right off the bat. to use it. Are we clear on last time you had contact with him?
Last night I talked to him.
He's down at the Dom, right?
Yes, sir. Yes.
Listen, I have a very strong passion for our veterans, and I want Jordan to do well. And I advocated for him to continue in my court when he absconded.
Yeah.
I want you to do well.
Yes, sir.
And right now, I will allow you guys to have contact with each other, but you understand that if you screw up or he screws up, I'm going to stop the contact because I
Yes, sir.
can't let you drag each other down.
Absolutely,
Does that make
sir.
sense?
Absolutely, sir. Yes.
So you either get along and don't. But if he drags you down or you drag him down, I will intervene, and because there's a rule in probation when you're on supervision.
Yes.
I'm sorry, keep it. There's a rule that you're not allowed to have contact with somebody else that's on supervision.
I appreciate
So I'm
it,
going to
sir.
allow
Thank
it
you.
for now, but if I see any signs that you are dragging him down or he's dragging you down, I'm going to stop it. We clear?
Thank you so much.
Do
Thank
you understand what I'm saying?
Yes, sir. I do. Thank you so much.
So when they put the monitor on you, they'll probably drug test you, make sure that you're
That's fine.
negative. If you come back and test positive for marijuana, there's not any excuses.
Okay.
It's not, oh, I took something and I didn't know what was in it.
Right.
You're responsible for what you put in your body.
Yes, sir. I
Do we
appreciate
agree
it.
on that?
Absolutely, yes.
All right, Mr. McKenna, is there anything else, sir?
No, Your Honor, thank you.
All right, very good. Thank you.
Thank you. Good luck.
Thank you so much. Thank you.
I got it. There you go.
All right, you're in the right place. Let's go back to Colonial Estates versus Zaleski. It's now 1/9/11. They're not here. I called the hall. What's the status here, Mr. Reed?
Thank you, Your Honor. At this point in time, with the total amount owed with court costs and service fee is $3,892.27.
Well, that'll help me for the judgment. How much is the rent?
So sure, $3,248.
That's through
through February.
February?
Yeah.
And this is lot only?
No, that's lot and house.
Oh, is it? Because it was listed as $470 per month.
470. So that is the lot. The house is 322. Is that correct, Rebecca? I know you're losing your voice. You can nod for me.
Yes.
Thank you.
So it's lot and trailer. Okay.
Yes, Your Honor. I apologize. I did not break that down. I can give you lot is 1,960. Lot is 1,288, but they both are rent, so I combine them.
All right. How much are court costs?
Court costs, Your Honor, $75 attorney fee, $54.27 service fee, $55 filing fee for $184.27 total.
Rebecca, as far as you know, is Mr. Zaleski still there?
Yes, he came in on Tuesday because we were renewing our leases, our lot leases, and I asked him what his plan was. And reminded him about court today. He kind of looked at me and said, I don't know, I gotta talk to my mom. and then I haven't heard anything.
All right, Mr. Reed, I don't think I have a judgment in here.
You don't,
You
I
can
can
send me
submit
one.
one. Yep, I'll send you one today.
All right, the date for the writ would be 10 days from today, which would be February March 7th. That's not right. I guess that's how it works. March 7th is a Saturday. So the first available day would be March 9th.
Okay. I will get that.
All right, thank you. You got one later, Cart. but
Yeah,
I
that
thought
one's
it
just, I filed
dismissed.
dismissal on that one. So that one's dismissed.
All right.
So,
Well, I'm sorry I won't see you tonight. Actually, I'm sorry I won't see Melanie tonight, but I want to
Yeah,
see
well-
you. That would be all right.
nobody cares
All
to see
right.
me. I get it. All right. Well, have a
All
great night.
All right, thank you very much.
Bye, Rebecca.
Bye.
All right, next up is we've got two FINRIC cases with two separate counsel. We got new lawyer Tanya Candido. Ms. Finnerman Rarick is here. I'm going to bring in Christine Yancey also. Oh, thank you, Christine Yancey form. All right, next up is FINRIC versus Webb. Mr. Curtis Webb is here. And in this one, counsel is Tanya Candido. Is that correct?
That is correct. Good morning, Your Honor.
Good morning. Welcome to Centerville. You ever been here before?
I have not.
Well, my advice is come in the summertime. All right. And Carissa Finnerman Rarick is here. So is Mr. Webb. Mr. Webb, I don't think you were here yet when I went through the advice of rights. So I'm going to take a minute and advise you what your rights are. This is a termination of tenancy case. This is a property that this corporation bought in Sturgis, and I think they're trying to get everybody out of there to redo it. I'm not exactly clear, but they served a notice to quit on you some time ago, and I think way back in November. At any rate, in such a case, a termination of tenancy case, you have the following legal rights. You have the right to hire a lawyer. If you cannot afford an attorney, you could seek assistance from legal aid. Usually the legal aid attorney is here with us on the live feed, but she's not here yet. I know she's going to be here, I think, in person later for some cases, but we sent you the number of legal aid with the pleadings. You have the right to hear the case or have the case heard here in St. Joseph County, where the property is located. That's where I am. You have a right to a jury trial. You've never had one. I've never had one in 23 years, but Judge McNally had one. So in 55 years, we've had one landlord-tenant jury trial. At any rate, you have a right to demand a jury trial. And if you wish to have a jury trial, you must file the demand in writing within 5 days of today's date and pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You may be able to reach an agreement with the landlord outside of court by going through mediation. Both parties are interested in that. Or you could reach some sort of agreement where you would come to a conditional dismissal that if you move by a certain date, they would agree to dismiss it. So, Miss, and it's always cumbersome to call you Finnerman Rarick, but I will refer to you as that. We had a couple of cases in this building before. This is a new building that your company purchased, and you're trying to get squared away on all of these units. Is that correct?
Yes, Your Honor.
Mr. Webb, what's your position?
I came in after they bought the place.
But yeah,
Anybody?
Yes, Your Honor.
Officer Sukovecki?
I have nothing further, Your Honor.
Mr. McKenna?
Nothing, Judge. She certainly looks a lot better than she did the last time I saw her. She, looked very much like a drug addict. And today she looks much healthier.
Ms. Bennington, what do you want to tell me?
I'm just grateful to get another chance at life. Genesis is an amazing program, and I wouldn't have got there if, all this didn't happen. So honestly, whatever happened, and I'm just grateful that I'm on the other side now.
All right, I am going to continue you on community control, order that you enter into and successfully complete the Genesis program, and you're going to go into their aftercare. We're going to find you a placement after that. The plan is to terminate you from supervision when you are in your post-Genesis placement. So good luck to you.
Thank you.
All right, that's all.
All right, thank you.
Thank you.
they that's pretty much my position. We pretty much got a mutual.
Well, let me see.
Well, we pretty much have a mutual agreement, but I just had.
I don't
surgery,
think
so-
you have a lease. Do you
Yeah, I
have a
have a
lease?
I have a lease. It's only about 2 months old.
Let me look here.
We have these two.
Your Honor, I believe I emailed you the lease, or your office the lease on Wednesday.
All right. Ooh, let's see here. Email correspondence. Well, today's Friday. Elaine, is there a lease in our email somewhere? So what's your position, Mr. Webb? You don't wish to move?
Well, the situation was I kind of rented the place without seeing it. And then I got here and the conditions are pretty nasty. So I had texted her and told her that I was going to try to find another place and break the lease. In that time, due to the conditions of this place, my wife lost her job because her carport fell on the truck. And I just told her to replace my windshield because we couldn't go so many days without having a vehicle because we both work. So I had her just pay for a windshield. It still took 4 days. So my wife got fired for missing 3 days of work. And then I got a lawsuit on her because I
Hold on,
fell
will
out
you
here.
sit down and stay in one place?
Sorry.
Walking around like this
My
makes
bad.
me itchy.
So I
Just a
fell out
minute.
here and got hurt.
Just a minute, just a minute.
Long story short, I just had surgery 3 weeks ago. I'm out of work for 3 months.
I don't have it. Oh, there it is, right in front of my face. All right. The reason I couldn't find the lease is because it was right in front of me. Is it not in on base or it
Yes,
isn't?
it is, but it's under the summons and complaint.
Oh, all right. Yes, it was received February 26th. So the lease is November 15th, and it doesn't expire till May 15th. So Ms. Candido, this doesn't appear to be a just cause termination.
So, go ahead, Your Honor.
When I first looked at this, I didn't know there was a lease. Apparently it came in 2 days ago or yesterday. It was date stamped yesterday. What's the legal posture of this case?
So, Your Honor, plaintiffs bring this eviction case pursuant to MCL 600.57141E. the defendant materially violated both the lease and statutory duties by, among other things, threatening physical harm and death to other tenants in the building. Such conduct would
Just a
constitute a
minute. Slow
serious
down a
breach
minute.
affecting the health, safety, and quiet.
You'll have to tell me quickly.
I don't see that in the pleadings anywhere. I see 1E. But I don't see any allegation of what it just says done by notice to quit. So you're alleging material violations of the lease?
And statutory duties, Your Honor, yes.
Where is that pled?
In our notice to quit, we put on the Michigan law.
You cited the statute, but you didn't allege any of the conduct.
I apologize, Your Honor. I'm looking it up. I'm pulling it up now. So yes, Your Honor, we cited the statute in our notice to quit to recover possession of property.
Well, that's
and then
pretty weak.
proceeded.
He doesn't know what's in the statute. You did cite the statute. We didn't cite any of the conduct. I didn't realize we had a lease until about a minute ago, and I should have seen it this morning. It was physically in the file. I don't know if it was there when I looked at it yesterday. All right, Mr. Webb, they want you to move. They didn't tell you exactly what you did other than violate MCL 600.5714, paragraph 1, paragraph E. You have any idea what that even means?
No, I got a pretty good idea what they're dealing with.
Well, they
There's pretty much saying you can't get along
more
with.
than this.
Pretty much saying you can't get along with all the neighbors. I mean, it's I mean, if you walk the halls once here, I mean, you can't go through the hallway.
Well, we
without
don't
bumping
need
into
it at this point. What I would like you to do is stay in one place. Gonna give me vertigo. I'm gonna fall out of my chair. I don't know why you can't sit still. All right, they want you to move. Now, the law says you're entitled to have an adjournment of at least 7 days. So that would take us to next Friday. You would get 10 additional days from that day, which would be March 16th to vacate. Do you think you can move by March 16th?
Well, I had planned on moving. It's just, I just had surgery, so I'm out of work for like 3 months. I'm off, no weight bearing for another 3 weeks. I don't go back to the doctor until the 10th. And then after that, I can start putting some weight on it, but I can't go back to work for I had planned on just saving and just leaving this place, but.
All right, well, okay, let's back up. Ms. Candido, I'd like you to file an amended complaint alleging what it is that he's supposedly being terminated for, citing the statute to a layperson, doesn't inform them of what the conduct is that they supposedly did to violate the lease. He's not gonna move because he doesn't have anywhere to go. So, we're going to have to continue this for a week, and then we'll argue about it further next week. But right now, he doesn't know what it was he did. When it was filed, there was no lease in it. And let's look at the calendar. Seven days from today is March the 6th. That's generally the first day of the month is very busy. Are you available at 1:40 March 6th, Ms. Candido?
I believe so, Your Honor. I'm checking right now. Yes, Your Honor, I'm available.
All right, we'll continue this to then. Mr. Webb, you did a good job of zooming in a timely manner, which I appreciate. All right, the allegation is that you have violated your lease, but you don't know what it is you supposedly did to violate your lease under just a general statutory notice. I didn't know either until we got here. There are other issues, perhaps regarding the covenant of habitability. One of the things they wanted to do is get everybody out of here so they could refurbish these units. This building had not been maintained for a long time, very well, before this company bought it. And I think they're trying to improve it. But threatening people and other things certainly isn't going to help your cause. Anyway, Ms. Candido, you have 7 days to file an amended complaint alleging what he did.
Yes, Your Honor.
All right, Mr. Webb, you got it. We're going to reconvene next Friday at 1:40 in the afternoon and discuss this further. Okay. If they get what they asked for, you would get 10 additional days from that day to vacate before you'd be subject to being evicted. You understand?
Yes, sir.
All right, do you have any questions?
No. Well, we can talk about it next week.
All right, I'll see you next Friday.
Thank you, Your Honor.
Webb, yes?
Oh, I just said thank you, Your Honor.
All right, I'll see you next Friday also. I'll remove Mr. Webb. All right, now let's do Fenrick v. Martin. We're a little behind schedule. Christine Yancey's on this one for the company. That wasn't a really good start with our new company. Anyway, Mr. Martin is here. This is a second hearing. We determined there was an arrearage. Defendant was going to Neighborhood Inc. I have the Christine Yancey official form, which breaks down the arrearage, which makes my life so much easier. Mr. Martin, they contend that your rent through February is $1,780. There's other costs, which include late fees for 2 months of $40 a month. She's actually included March's rent in here. So this would be through March. I'm not supposed to do that, but we'll deal with it. We've also got an electric bill of $80.
No, we don't owe that.
And $217.25 of costs. For the total would be $2,077.25.
I don't understand how we owe the electric bill. We pay our electrics in our name. It's in our name.
Your Honor, my client has sent, there was some text correspondence that went on with regard to the electric bill that it was owed, but my client's willing to forgo that $80 just to resolve this matter, to just get that the rest of the rent paid. Because he's got the 10 days within which to make that payment, March will become due. So that's why I added that in. I did not add a late fee.
Yes, we used to do it that way. Judge Stutzman ruled that I can't do that. About half of the judges, I used to do it all the time during the COVID emergency funding money, so they could go to the funding agency and show how much their entire rent was. But this will, I'm not supposed to do it.
And I
But I'll-
do have, Your Honor, the other figure handy. That was the figure that we had done for last time. And I guess you could use that judgment again as well.
All right, I'll use this one. There's no March late fee because March isn't here yet.
Correct.
Mr. Martin, they will take the $80 of the electric bill off of there.
Okay.
So through March, it also makes it more understandable to the client how much they owe. He has gone to Neighborhood Inc. And did you have any success with them?
They said that they're out of their price range, that they can't help. They're above fair market rate, they said.
So they can't help us.
Well, we don't have much rent under $850 unless it's subsidized.
Well, this
then
was
you're not
$650.
eligible.
This was $650, so she took it over, and then she bumped it up to $850.
And did no renovations.
Well, $850 is currently market rate around here. There are plenty of places now renting for over $1,000. All right. Well, anyway, you're gonna either have to pay it or figure out what you're gonna do and move.
Right.
I'm gonna take $80 off of it.
Okay, thank you.
So 207.7 minus 80.
We have to be March's rent. Yeah, 2,000 a month.
1,997.25.
That's 2 months of rent.
Your Honor, would you like me to send over another judgment form that?
This will be fine. I just made some changes. The date for the writ is, again, you did the same thing I did. The first business day would be March 9th. So that's the date for the writ and for the appeal. Partial payment will not prevent the writ of eviction.
So we have to pay February and March's rent by what date?
Well, Your
You have to
Honor.
pay the entire amount.
Okay.
Otherwise, you're still subject to being evicted.
But we're not even, it's not fair.
You can work out something with the landlord to try to get caught up. But by the letter of the law, unless you pay that entire amount by March 9th, you're subject to being evicted.
Even though it's only 8 days late.
My advice is always stay in contact with your landlord. Now, when you do move, if you do move, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. This judgment does include March's rent. March isn't here yet, but it makes it more, it's unlikely you're not going to move by tomorrow. So I allowed it to stay in there despite the contradictions in the law. All right, you owe $1,997.25 to pay your rent, 2 late fees. There'll actually be another late fee after March 1st, but it's not included in here. The utilities is taken out of there.
So by March 9th, we have to pay March's rent, or we're even get.
By March 9th, you have to pay February's rent and March's rent.
See?
And the attorney fees, and the late fees. Or you're subject to being evicted. All right, I'll send you a copy of this judgment.
Thank you, Your Honor.
I am surprised that Neighborhood Inc. felt $850 was outside of market rate.
They're only allowed $777.
Yeah, they're only allowed $777 is what they're allowed to give.
Many places that rent for less than $777.
I know.
But even if they gave you $777, it would still help to cover the shortfall.
That's what I said, and they said they have to be able to pay it all or they won't do it. I didn't understand it either.
I don't know what their rules are, but I'm telling you, we don't have very many places that are under $770 unless they're subsidized. And if they're subsidized, they're not eligible for Neighborhood Inc. assistance.
Right.
So it's a catch-22. All right, Mr. Martin, I wish I had a better answer for you, but that's the answer. All right, you're good to go.
Thank you, Your
All right.
Honor. Thank you,
All
Carissa.
right.
Thank you.
Carissa, this went a lot more smoother than the other one, so I'm not sure what's going on, but
No,
Yeah, sorry
I'm still on that just because of a different circumstance.
oh, so you're still going to be representing this company?
Yes.
Yeah, that's not gonna happen again.
All right, good. Okay, thank you.
Thank you.
Your Honor.
All right, thanks. All right, next, we've got Village Manor versus Felicia Hotel. Miss Hotel is here, or Ottle. That matter has been dismissed without prejudice by the law firm for Village Manor. So Miss Odell, you must be squared away.
Yes, Your Honor.
I just signed the order of dismissal and you're good to go.
Okay, thank you so much. Have a great day, Your Honor.
All right, thank you. All right, that brings us to Patricia Aarons on behalf of the Hines Estate versus all occupants at River Lake Drive, Three Rivers. I believe Dean Hines is here on that matter. And Mr. Mast, are you here on that matter as well?
I am, Your Honor.
All right. What the notice to service said is that Timothy Mast was there and said Dean Hines comes sometimes. Miss Ayers, is Mr. Hines your brother?
Good morning,
You're
Your
on
Honor.
mute.
Andrew Horn on behalf of Patricia Aarons as well.
All right, and the distinguished Andrew Horn from Vicksburg is here on behalf of the plaintiff. So let's talk about this. We get these periodically where it's part of an estate. You know, the siblings aren't always on the same page, or there are issues that property needs to be sold. So Mr. Hines and Mr. Mast, you as the occupant, you are tenants in a termination of tenancy action. The plaintiff, in this case, the personal representative or next executor or I'm not sure the word I'm searching for, guardian of the plaintiff wants you to move. As such, you have a right to hire a lawyer. If you cannot afford an attorney, you can see if legal aid would be willing and available to represent you. Got two people in the waiting room. Let me bring them in, see who's here. All right, someone's here by telephone. The Larkins are here, Mr. Larkins and his able assistant. Who's here by telephone?
Haley Ragland.
All right, let me give you a proper name.
Morning, Your Honor.
Good morning. Ms. Ragland, you're also here as a tenant in a landlord-tenant proceeding. In your case, it's a demand for non-payment of rent. Mr. Mast and Mr. Hines, yours is a termination of tenancy. In either case, you have a right to hire a lawyer. You have the right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this appearance or be prepared to file a written demand within 5 days of today's hearing and pay the $50 jury demand fee, lest the judge waives the fee for your inability to pay it.
Okay.
If your landlord has asked you to be evicted from non-payment of rent, you may be able to get its emergency housing assistance from the Department of Human Health and Human Services, Keystone, Neighborhood Inc., or Community Action Agency, or if you're a veteran, you may be eligible for some veterans benefits. You may be able to reach an agreement with the landlord by going outside of court and attempting to mediate the matter. And if that resolves the case, that would not require a need for further court hearing. You also could reach an agreement with the landlord that would result in a conditional order of dismissal, which case Mr. Horn would prepare that and file it. All right. Good morning, Mr. Horn. It's nice to see you again.
Morning, Your Honor.
All right, and again, we've got Patricia Ahrens, the guardian. Dean Hines has an interest in this property, and Timothy Mast, I believe, is living in it. Mr. Horn, what's the circumstance here?
Your Honor, this property is owned by Carol Hines, solely by Carol Hines. She was moved into a rehabilitation or assisted living facility last year. And since that time, there's been somebody living at this property. In December, the circuit court ordered, in order to protect her and protect her assets, that Patricia Ahrens was ordered to evict anybody who was at that property and sell the property.
To change his plea this morning. It's going to be pleading guilty to the one count of the indictment, failure to comply with an order or signal of a police officer, felony of the 3rd degree. We're going to be then requesting a PSI and set this over for sentencing.
All right, Mr. Mason, is that accurate?
That's all accurate, Judge.
Okay, Mr. McGinnis, you're telling me you're going to change your plea to one count of the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
All right.
How old are you?
19.
How far did you go in school?
I graduated high school.
Can you read and write?
Yeah.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Mason?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
Do you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of failure to comply with the order or signal of a police officer. As a felony of the 3rd degree, that carries a maximum penalty of 60 months in prison and a maximum fine of $10,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
This also carries with it a mandatory operator's license suspension of anywhere from 3 years to life. Do you understand that part of it?
Yes, sir.
You're also subject to a mandatory period of post-release control, which means if you are sent to prison upon your release, the adult parole authority will supervise you for a period of not less than 1 year, nor more than 3 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison. The court does have discretion to place you into community control or what some refer to as probation. While on community control, you'll have rules you must follow as well. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you would have a right to see and hear all the evidence that the prosecutor has against you. With the help of your attorney, the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's called your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. And if you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you can also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
That's how you wish to proceed.
Yes, sir.
All right, Ms. Tranter.
Your Honor, in addition to the facts alleged in the indictment, this offense occurred September 18th of 2025, Warren County, state of Ohio. Mr. McGinnis on that date was operating his vehicle over the posted speed limit on 71 southbound. Officers attempted to pull Mr. McGinnis over by activating lights and sirens. Mr. McGinnis increased his speed. Officers reached speeds of up to 130 miles per hour in attempts to catch up with the car. Mr. McGinnis then exited 71 onto Kings Mills, running a red light at Kings Mills at Courseview Drive. Officer was instructed to discontinue the pursuit due to public safety concerns, but as the officer was slowing down, Mr. McGinnis went off the left side of the roadway, crashed into a small tree, and he was found to be the sole occupant and driver of the car.
Mr. Mason, anything on those facts?
No, Your Honor.
Mr. McGinnis, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights you and I went over.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Mr. McGinnis, I'm not going to get into this matter of sentencing today. I don't know enough about you, quite frankly, to sentence you. So I'm going to order a pre-sentence investigation. We'll come back in a few weeks to do sentencing at that time. I do recognize that you have been compliant under the terms and conditions of your bond, so you'll be able to remain free on the same bond arrangements today as when you came in here. Ms. Tranter, is there anything else?
No, sir.
Mr. Mason?
Your Honor, I was just, apparently I misspoke in our pretrial discussions. He now has Aetna insurance rather than United Healthcare, as I understand. I sort of had it.
Doesn't make
but
any difference
At
to
any
me.
rate, we will try to get that evaluation done right away.
Okay, and then again, he'll be assessed by Talbot House, and we'll get that assessment done as well. All right, thank you all. Mr. McGinnis, you need to go back down to court services where you checked in this morning and set up your interview.
All right.
All right.
Earlier today, I already did it.
You did what?
I spoke to my.
I know. So I'm saying you have to go back down because now they're going to do what's called a pre-sentence investigation. It's a two-part. One's an interview by court services. The other is an assessment by the Talbot House to see if you have any substance use disorder or mental health issues that we need to be perhaps address. It's a two-part assessment. You just need to comply with that. Okay. All right. Thank you.
And Judge, should I see your assignment?
All right, this is case number 25CR43075, the state of Ohio versus Joseph Gilmore. Ms. Gilmore, the court has been presented with a nollie on Mr. Gilmore's case. Do you know anything about it? I understand he died.
That's my understanding as well, Judge. I think he's deceased, so we're just.
So the prosecutor wants to nollie the charge.
Correct.
Or the indictment. Okay.
Yes.
At this time, the court will accept and approve the nollie. Thank you.
Mrs. Hines has been deemed incompetent by the circuit court. So any idea that she signed any documents would be, I mean, fraudulent, if not ridiculous.
All right, well, let's see where we are here. Mr. Mast, you're living there?
Correct, Your Honor.
How long have you been there?
I've been here since late April of last year.
Under who? How did you come to move in there?
I asked Dean if he could talk to his mother, Carol, and see if I could live here for a while because I was in a not a great situation. And he got permission from her. We wrote up a lease, and I've been here ever since. My rent is just to maintain.
Do you pay any rent?
Yes, I pay Carol's bills, the electric, the gas, the house insurance. I pay for the yard maintenance. Anything that needs to be done around here.
All right, but no actual rent.
No actual rent.
Do you have a lease?
Yes, I do. You should have that. I brought that in, I believe, last week.
I don't have the copy of that, Your Honor.
I have something that was filed February 18th called residential lease, landlord Dean Hines, but Dean Hines doesn't own the property. I'm not sure when this was executed. Let's take a look. It may have been done just for purposes of this. Mr. Hines, what's your position here?
My position is that I was taking care of the property and Timothy needed a place to stay. He had been in and out of there since 2012 with my mother's permission. He had my mother's permission to stay there. We have a prior lease. We didn't think we would have to include that, but we can. She was aware of it. I had her permission, and I have documentation of that.
Well, at this point, your sister has been appointed as the guardian for this property, and the court has directed her to sell the property and get everybody out of there.
Correct.
So
you have an issue with that if I'm allowed to speak?
Say that again?
I do have an issue with that if I'm allowed to speak.
Tell me about that.
I was never served proper notice of the court hearing, and the probate court verified that.
Well, you take that up with the probate court. At this point, she has lawful authority as far as this court is concerned to do what she's doing.
Right.
Whether or not you have a challenge to that, I don't have jurisdiction over that.
Right.
Mr. Mast, you need to prepare to move out. I'm going to continue this matter until next Friday. Mr. Horn, are you available next Friday, March 6th?
I will make myself available. Yes, Your Honor.
I think at this time, Mr. Mast, do you have anything to say, if I may?
We would like to take this to a jury trial if we can, because the way that Patty has gone about everything behind everyone's back.
All right, well, you have to file a jury demand within 5 days. All right, do you know anything about the rules of evidence or procedure or how to file jury instructions?
No, but if you could inform me, that would be appreciated.
Well, I can't. You can seek guidance from legal aid, but if you do wish to have a jury trial, this will be a fiasco. So let me repeat this. Patricia Ahrens has the lawful authority to prepare to sell this property. Probably some of the money is needed to pay for Ms. Hines' care. So by you staying there, she can't use the value in her house to pay for her care. So the court has directed the guardian to get you out of there and sell the house. You're not paying any rent. The person who you signed the lease with doesn't own the house. So you can ask for a jury trial. You're going to have to represent yourself unless you get legal aid to represent you, and you're going to be in way over your head. In the meantime, you're causing this lady not to be able to use her equity in her home to pay for her care. But at any rate, we're going to continue this to 2:15 next Friday, March 6th. Then we'll discuss it further. If you do file a jury demand, we'll set a jury trial and see what the jurors think of your lease by someone that doesn't own the house.
Your Honor,
At any
it's
rate,
also
that's
worth
where we are
noting.
currently. My advice would be you could contact legal aid and ask for some advice.
I had already.
But let me repeat, you signed a lease with someone that doesn't own the house. The guardian has been directed by the court to sell this house, and you staying there prohibits Ms. Hines from using this money to pay for her care. So consider all that. All right. Anyway, we'll address this further next Friday, March 6th at 2:15. All right, Mr. Mast or Mr. Hines, do you have any questions?
I'm probably going to be retaining an attorney soon.
Say that again, Mr. Hines. Can't hear you.
I'll probably retain an attorney as of Tuesday.
All right.
So I don't know what Mr. Mast is going to do for an attorney, but we'll figure it out.
All right. Okay, as I said, this comes up a number of times each year. We probably had 10 of them last year. Grandpa dies, grandson was in the house, siblings don't agree. But there's more going on here. There's a circuit court case. I think it's actually a probate court case, family court. But all right. Anyway, I'll see everybody next Friday at 2:15. Thank you.
Thank you,
Your Honor. Just briefly, one more item on this. Mrs. Hines has now been disqualified from Medicare because they consider that there's a renter in there, and so she's not only not getting the funding for her care, she's actually lost the funding for her care. Absolutely.
May I speak as well? May I speak as well?
Yeah, just a moment.
Okay.
Yes, go ahead.
Carol Hines's home is under a reverse mortgage, and for every month that this drags on, they are charging against my mother's estate $1,070. I figure since October, when I began these proceedings, she's already lost $4,000 in equity in her home. So every month that passes, the more money that is likely to come out of anything that may be left after the sale of the home.
All right, so Mr. Mast, your being there has caused her to lose her Medicare eligibility because you're considered to be a
She's under Medicaid, Your Honor. I'm sorry to interrupt.
Medicaid.
Yeah, so that I think qualifies from what I've been told, as Medicaid fraud, because those monies should be going toward the facility in payment for her care and treatment there.
So even though you're not paying rent, you're paying the utilities, the insurance, the gas, which is income to her because someone's paying the utilities, rent, and gas. So you're a tenant at her house. So one additional new fact, it's costing her $1,000 a month for you to live there. And you being there has caused her to lose her Medicaid to help pay for her care. All right. Sometimes you just need to do the right thing. But we'll discuss this further next week. All right. Thank you.
Thank you, Your Honor.
Remove Mr. Hines. Remove Mr. Mast. Remove Ms. Aarons. All right, there's more to that story than meets the eye. Interesting facts. His tenancy makes her ineligible for Medicaid. All right, we have Scott Larkins and his property manager, Caitlin Thornton, versus Haley Ragland. Ms. Ragland is present, and she did hear me go through the rights here just a moment ago. This is a non-payment of rent case for a property on Broadway. I think this is the one. No, this is 132 North Main.
Oh, no, that's our office. So it is a property on Broadway, 612 and a half.
Oh, it's six. Yes, it's the property on Broadway that we've had a number of cases on that one. Yeah, that's your office. All right, Miss Ragland, what's your position?
I mean, I definitely have been going through a really hard time. I lost my car. It was actually stolen like 2 days after Christmas. And so I have not been able to like get out and work and stuff. So I definitely have not been paying my rent. So,
all right, well, let's calculate
right.
how much the rent is. Ms. Thornton or Mr. Larkins, can you tell me what the rent is?
As of right now, the rent owed is $2,950.
And if we add next week, how much would that be?
That's an additional $225. $3,175.
What are the court costs?
Let's see, $175.28.
$3,135.28. We'll call that through 228. Miss Ragland, if you can't pay your rent, you're going to have to move.
Yeah, I definitely know that I have to move, but I'm having like an issue because I don't have a car to get my stuff to storage. So I kind of need more than like 7 days so I don't have to leave a bunch of stuff for them to.
Yes. Well, the law requires we adjourn this at least 7 days, which takes us to next Friday, March 6th. Mr. Larkins and Ms. Thornton, are you guys available next Friday at 2:40?
When do you go to Utah?
What's Anna?
6th.
I will not be. We can get an attorney to fill in for me.
Or we could go to Monday, the 6th, the 9th, if that works better.
How about Tuesday?
We got criminal cases, you know, we're in the middle of a preliminary examination on a criminal case.
Well, just schedule for Friday, and I'll see if I can get an attorney to fill in for me. I'm gonna be in Utah on a ski trip.
All right. Well, you can appear by Zoom. You have done that before, but maybe you don't want to get off the slopes at 2:40 on a. All right. Anyway, Ms. Ragland, we're going to adjourn this matter to March 6th at 2:40. And if they get what they ask for, we'll have an additional week's rent at that time, which would be due. But they're going to tell you have to pay that amount of money or you're subject to being evicted. You get 10 days from March 6th, which would be until March 16th. But every week that you stay there, they're $225 more in the hole, which will be hard for them to collect. They've got a waiting list of people that are ready to rent this apartment. So essentially, at this point, you've got until March 16th to move or be subject to being evicted.
Yeah, so they really can't rent this place out to anybody until it has to have a lot of work done to it that they were not fixing and stuff like that. Like I can't even use the kitchen sink because the water doesn't go down, and I have paid people to come and try to fix it, and aside from that, there's a couple other things here that have
All
to
the
be fixed
more
before
reason why
anybody
you want to
can.
get out of there.
Right, and I
places
do.
in the
I
city
do.
are inspected.
Your Honor.
Yeah.
She used to live in another house with her husband or boyfriend, I'm not sure, and they split up. So we put her in there temporarily.
Yeah.
And then our plans are to rehab the house when she gets out, but
yeah,
she was always supposed to be in there temporarily, and then we were going to move her into another apartment, but we had to move her in there because she had a bad situation where she lived. She got through a divorce or breakup of some sort. So this was only supposed to be.
And they really did help me. And I plan to, when I get my taxes, to pay, regardless of moving out.
No good deed goes unpunished. If you do pay it, Ms. Ragland, you get to stay there. If you don't, you're subject to being evicted, and maybe the best thing to do would be to use that tax refund to get into the next place.
I've already
We'll
applied.
address it further next Friday at 2:40. I'm sorry, what did you wish to say?
I was just gonna say that I have applied for like some income-based places, but I still would like to use like my taxes to be able to catch up, because they did do me a favor. You know what I mean? They didn't have to, move me into another place and help me out, but they have.
That would be great too, if you did pay it. But the problem is, all the income-based places have a waiting list, and there's more demand for housing than there is housing. Certainly.
Yeah, I found the place that I found, my friend got in after applying for 2 weeks. So I'm hoping that it's Maple Crest.
All right.
She turned her app in, and 2 weeks later they called her, and she got to go in and fill out like her paperwork and stuff like that to be able to move in March. So I'm hoping that's going to be the same case with me, because they have like 9 or 8 units available.
All right, very good. Hope that works for you. And if you pay them, all the better. All right. At any rate, we'll address it further next Friday at 2:40.
Thank you, Your Honor.
Okay.
Thank you.
Thank you.
Thank you. I'll remove Miss Ragland. All right, next up is Kark Properties versus Richard Hill and all other properties. That is set for 9:50. And that is a dismissal by Mr. Reed. That means we have a bit of a gap here. We don't have we had a 10 o'clock hearing, couple of them which were removed. Usually in the middle of our landlord-tenant docket, we have several unpleasant 10 a.m. general civil cases. Those have been resolved or relocated. So we aren't back until 10:45. So we'll stop the live feed. I'll take a break. We have 10:45, 10:50, 10:55, 11. And then theoretically a bench trial this afternoon. So we'll stop our live.
Okay. Jeremy Javon Christian, 21B138482A, 21B138966A, 21B139004. Your name, sir?
Jeremy Javon Christian.
Ms. Patillo?
Good morning, Judge Deanne, TOPA 2378 on behalf of Mr. Jeremy Christian.
All right. So let me see what I have here. Looks like on July 11 of 24, and I'm referring to the 181384828 case that Judge Simpson, in my absence, took the plea, of course, sent it back to me. the sentencing, there were multiple charges. I'm gonna need whoever's on this case, John. Can you have them come in? Jeremy Christian and probation. It looks like failure to report, failure to attend 12-step meetings, failure to attend victim impact, failure to pay fines and costs, failure to clear warrants, and consuming alcohol or drugs. So let me just, these files are old and defendant did not show up. So that's not good.
Judge, one of the reasons he didn't show up is because it looks like he was supposed to be sentenced on that probation violation and the sentencing for the reckless driving and the resisting and obstruct on August 28, 2024. He went into custody from Macomb County. So that he wasn't in there long, but that was one of the reasons he didn't come back.
All right, let me just double check the other cases too.
I think
I also have a reckless driving. These. Jessica, can you come on up here, please, and state your name? Do you have the show causes? These files are.
I have is the file that this is like a victim notice letter. That's the only file that handy.
Yeah, because two of them, he hadn't been sentenced. Yeah, the OWI, I think is the only one he was put on his probation for.
Oh, yeah. Okay. That's what happened. Let me just double check.
And I could be.
You're right. He was not sentenced. That one. Well, because those were from June of 21 offense dates, and the other was from January 10 of 21. So what I'll do is we'll go ahead and proceed with the sentencing on the drunk driving. And I'll set these over for sentencing, but I'll have to take a look at these files. Actually, I'm not sure I shouldn't just set them all at the same time. I think that's what I'm going to do. And I'm going to ask you to find the show cause on the drunk driving. Where does he live at? Does he live in Sterling Heights?
No, it's not Michigan.
What's the address?
26665.
26665?
Yes.
Okay.
West Carnegie Park Drive.
West and then Carnegie,
NEGI.
Drive, and that's in, you said, Southfield.
Yes,
Does he work?
he does. He just started his job at Chrysler on Monday, February 16th.
What is the zip code there?
It's either.
I don't know the zip. I just moved there, sir.
It's 48076 or 48075. I think it should be one of those.
Well, you got a history of non-appearance, Mr. Christian.
I know, sir. And like I said, I was homeless. I lost my job. I've been incarcerated. I've been trying to take care of everything.
We haven't been trying to take care of everything. Come on.
I have been trying to take care of everything.
How long were you in custody when you were supposed to be here in August of 24?
About a month.
Why didn't you show up here then?
Because like I said, sir, I was homeless. I had no help. When I got released from jail, I was living on the street. I didn't have any help.
Have Heather pop on here. Have Heather pop on, please.
I've been working for Chrysler for 7 years. And like I said, I've been laid off for the past 2 years because they downsized. So I've been homeless and working as hard as I could to live.
Yeah, but you've been playing games on this case since 2021.
Like I said, sir, I know. I'm sorry. And I'm just trying to take care of it. If I can get them all done on the same day and just come and do what I need to do, then I can do that. I just started back working and now I can take care of everything.
And Judge, in his defense, as I was going over, because he does have some ugly warrants out there, as I was going over everything, he's aware of everything. He's looked into everything. He's finally back to work. He doesn't want to lose his job because then it'll put him back at square one.
There's no way in God's name that I'm letting him go on a personal bond. There's no way. This guy's been playing with us for 4 years. I don't know who he thinks he is.
The judge, would you consider 5,000, 10%?
He's gonna pay a lot more than that. I'm sorry. He made his own bed. Now he's gonna get in the thorny thing.
Sir, can I please get a bond that I can at least pay today so I can go back to work and be able to handle the case?
It's too bad that you've done this to yourself, son.
I know, and I'm not
It's too
taking
bad
anything back.
that, I'm not done talking. It's too bad that you've done this to yourself. We are not a convenience store here. You don't get to stop in when you feel like it. This is an obligation that you had.
Yes, sir.
I mean,
Sir, can I say one thing, sir?
in a minute.
Okay.
Just for the record, Judge, as for the arraignments, she stands mute and we wait for him to read.
Is Heather popping in, John?
She was on the phone. I had to call Kim to let her know to have Heather log in.
Okay. Will you make sure that in the drunk driving file that I have, these files are so thick,
Yes, I will make sure.
the show cause.
Thank you.
I don't want to set these out as far as she's got them. But I do need time to review these files. She's got this for the middle of March. Heather, this gentleman's been ignoring us for 5 years, basically. I need a sentence date and I want it to be closer as the point. Of course, I'm going to be gone. Boy, so I need a sentence date of 21B138482A. That's for a violation of probation. That's the drunk driving. And then I need a sentence
This is
date.
Jeremy Christian, correct, Judge? I just want to make sure I have the right person.
Yes, and then I need one on 21B and 1389666A and 21B139004.
Okay, I believe we had the sheet out there and I believe we gave March 4th as the earliest.
Sorry, I thought it said March
Wednesday.
the 14th.
Oh, I'm sorry. Yeah, no, March 4th.
No, that was my fault. I apologize.
I didn't do the slash big enough.
So the sentence date will be March the 4th, and that'll be at 11 a.m. What would you like to say, Mr. Christian?
I would like to say that I apologize for all of that, all the drama that has been, but I just started back working. I'm just trying to do everything right, sir. I've been laid off work for 2 years. I've been homeless for 1.5 years. I'm just not getting back together, and I just want to be able to take care of everything. I'm not trying to give you a runaround. I just want to be able to take care of it, sir. That's it.
He also
I'm finally able. I've been, like I said, sir, in the past 1.5 years, 2 years, I've been shot. I had to sit in the hospital. You can see my hand. I've been shot. I had to go through therapy. I was in the hospital for this. I've been to jail, and now I'm just not. Everything is coming back together, so I just want to take care of everything. If I could
Thought about this. You don't want to take care of everything. You don't. Please don't tell me you wanted to take care of these. That's not.
I said I want to. I said I want to.
That's not truthful. It's not truthful. You're in a courtroom. I don't want to hear lies.
I'm not telling any lies.
I don't like this nonsense when people think they can ignore the system like they're bigger than life. Shake your head all you want. On drunk driving, spending in 482A, 7,500, 10%. I'll incorporate the other two onto file 3896668A and 21B139004, 6,000, 10%. Sentence will be March 4th at 10. You have to post $1,350 to secure your release. Good luck. We'll see you here then. Thank you. Thank you. George Jalen Hitt, 258149447, A and B. 25B149222B and 25B149222A. So I got 447A and B, and I got 222A and B. Your name?
George Hicks.
Where you been? Where have you been?
Well, I missed the show calls here because I had my dates confused. That's it. So that's why I came in today.
You got all this money to pay?
Not for every ticket, but I can afford to. I can give 200 today on
That isn't even gonna make a dent in these. You owe 230, you owe 260, that's 490, 230 is 720, and 407 is $1,127. And you can only pay 200. Why? Where do you work at? Why didn't you show up on any of this?
I had my dates confused. I actually got.
Did you graduate high school?
Yes, sir.
Then come on. What do you mean you had your dates confused? I don't understand the confusion in dates. We give you a date, we give you a paper notice, put it on the fridge, put it in your phone calendar, write it on your forehead if you need to. You don't not show up. Where do you work at?
By the airport, it's called KOS Logistics.
On 447A, you're going to pay right now $200. You owe $225. Balance waived. So I'll save you $25. On 447B, you owe $195. When can you pay that?
Is that the no insurance thing?
That's the headlamps. If you think you're coming in here to get me to let you pay the no insurance so you can get a valid license and not pay these others, that's not the way this is going to work.
No, that's not what I'm trying to do. I was trying to pay 200 today on the no insurance.
No,
and then
no, you don't get to decide which one you're paying.
well, whatever one you want me to pay, I just have 200 to pay, and then I wanted to get on a 125 every week.
Okay. On that one, on 447B, you pay $125 per week, beginning March the 9th. Can you do that?
Yes, sir.
If you don't have the money, you call the court and then you pay $125. After you pay that one, you can pay the no insurance. That's $407 now. You managed to make this $407. Do you realize that?
Yes. And possibly with the phone call before I leave the court today, I might be able to secure the other two. So it can go, to wherever you would like that also.
Mr. Gibbs, Ms. Nicholson on behalf of the state of Ohio. Ms. Nicholson.
Your Honor, it's my understanding the defendant will be entering a guilty plea to the indictment, which is one count of aggravated possession of drugs, a felony of the 5th degree, and there will be a joint recommended sentence of 6 months in prison consecutive to his current prison sentence.
Mr. Gibbs, is that accurate?
Yes, Your Honor.
All right, Mr. Fields, you're telling me you're going to change your plea to guilty to the one count of the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I'm 33, sir.
How far did you go in school?
GED, and I took 2 college courses since I've been incarcerated, sir.
Okay. Are you able to read and write? Okay.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you other than this recommendation to me that I sentence you to 6 months to be served consecutive to your current sentence? Is that the extent of any representations made to you?
That was the deal, but no one promised it to me.
Right. I understand. Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Gibbs?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what we're doing today?
No, sir.
I have in front of me a document. It's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the 5th degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control on this case. I think your current case is mandatory.
Yes, sir.
But I'm required to explain it to you.
Okay.
All right.
Okay.
So on this case, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, The adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to, okay?
Okay.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished in any way unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury, and if you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Gibbs, the right to confront and cross-examine each of the witnesses. Do you understand that?
Yes, sir.
You have a right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you choose not to testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed, and you could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you feel like you understand each of these rights we've gone over?
Yes, sir.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We're not going to have a trial.
Right.
This is how you want to proceed?
Yes, sir.
Okay.
Your Honor, if this case would have proceeded to trial, the state would have proven that on or about March 6, 2025 at Warren Correctional Institution located in Turtle Creek Township, Warren County, Ohio, the defendant, who was an inmate at Warren Correctional Institution at the time, had his cell searched looking for contraband. A search of his person was also conducted in which he was found to be concealing a white object on his body. That substance came back as 5-fluoro-AVB, which is a synthetic cannabinoid.
Mr. Gibbs, anything on those facts?
Nothing further, Your Honor.
Mr. Fields, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed.
Yes, sir.
What is your plea?
Guilty, sir.
All right. The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts of your plea, the court will make a finding of guilty. Ms. Nicholson, anything before I pronounce sentence?
No, Your Honor, we just ask that you adopt the joint recommended sentence of 6 months consecutive to his current sentence, which I believe has an earliest release date of May of 2035.
Is that a Reagan-Tokes?
No, sir.
Okay. Mr. Gibbs, anything?
Your Honor, I would just like to note, well, again, we have agreed to this joint recommendation for the sentence, that Mr. Fields is taking many steps. He has attested to me over 50 different certificates. While he has been incarcerated, he's certainly looking to move past this and make the right steps forward for a productive future.
Okay. Mr. Fields, is there anything you'd like to say, sir?
I haven't had any trouble since this incident. It's been a year. I got rolled out to a higher level, and I've been up there about 13 months. I'm probably got about 6 more months to do up there, and I haven't had any tickets or anything like that, sir. You know what I mean?
Where are you?
Okay,
where are you housed now?
OSP.
Okay.
Ohio State Penitentiary, sir.
Okay.
And yeah, like I said, I've been up there 13 months, ticket free, staying out of trouble, working my levels, working my way back down, and I'm currently taking recovery classes up there, and I'm signing up for college again.
Okay. All right. All right. The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So, Mr. Fields, I'm going to order you to serve 6 months in prison, that to be served consecutive to your current sentence. The court will make a finding that the consecutive sentence is necessary to punish you. It is not disproportionate to the conduct of the defendant, and this offense occurred while the defendant was already incarcerated in the Department of Corrections. You have 0 days jail time credit on this 6 months. The court does find that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control, which I went over with you a few minutes ago.
Yes,
Do you want me to go over that with you again?
Yeah, just real quick.
That's fine.
I know you said like.
Well,
so
I
for
think,
this
what are
case,
you in for now?
Vehicular homicide.
Okay, are you
car
on
accident.
mandatory PRC?
I think so. Yeah. Yes.
Okay, so when you get out, the adult parole authority is going to supervise you on that charge.
Okay.
This one is not a mandatory PRC. It's discretionary, but you're going to be under supervision with them anyway.
Right.
This one is discretionary, which means that they could supervise you on this one for up to 2 years.
Okay.
I think yours is 1 to 3 on your current charge.
Yes, sir.
And I don't know, they may pick 1, 2, or 3. I don't know what the answer is. This one's up to 2.
Okay.
If you violate the supervision on this case, the adult parole authority can send you back to prison for up to 3 months.
Okay.
If your violation is that you've committed another felony,
sir,
they can send you back to prison or the sentencing judge in that case can add time onto your whatever. If he sends you back to prison, he can add either 1 year onto that time for PRC time,
yes, sir.
or whatever time left you have on PRC. So if you still have 2 years left and you go out and commit another felony, and he sends you back, another judge sends you back to prison, he can add up to 2 years onto your sentence.
Okay.
That would be consecutive.
Okay.
Most judges, I think in my 10 years on the bench, I think I've only added PRC maybe twice to a defendant. Usually they try to work that out, but it's a possibility.
Okay.
All right.
It's just it's just discretionary. If they, on my original case, if they pick it up.
If you're I'm going to guess, and again, I don't control the adult parole authority. I'm going to guess you're on mandatory PRC, that they're going to just not enforce. They're not going to do PRC on this one too. It'll just be, you'll be on mandatory PRC. But the idea is still the same, and the penalties that you would incur on that case are more severe.
Yeah, are more severe. So basically, just
be
be mindful of it.
Yes, sir. That's exactly the point. Okay. Now you do have a right to appeal this court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal it, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me, sir?
No, sir.
All right. Good luck. Best of luck to you.
Thank you. Thank you. Appreciate it. Thank you. I would appreciate it.
Boy, everybody's mad. All right. Case dismissed. That's without prejudice.
Thank you, Your Honor. That covers our cases for this morning. Have a great weekend.
You do the same, sir. Arbor Woods versus Sarah Ellison.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
And good morning. Do we have her?
She is here.
Sarah Ellison?
Wow. I did have her checked in.
You did have her checked in. You think she dropped? I'll pass this matter. We might have lost her. Arbor Woods versus Carlos Hatchett. And Mariah Gibson.
Oh, there we go.
Okay, yes, that's you too. I'll need a camera, Miss Gibson.
Okay.
All right, what is plaintiff's claim in this case?
With cost, Your Honor, $3,771.15.
All right. And Ms. Gibson, how are you intending on getting this paid?
It'll be paid. I need a couple of weeks because I have been out of work for the past month because I had messed up my knee. So I haven't been able to work. And then my brother, he's a college student and working part-time. So he's not making the best money right now for us to work together like we've been
So
doing to pay it.
you're indicating in 2 weeks you can get this paid, you think?
I don't think I can do it in 2 weeks, maybe like less than a month though.
Well, the problem is that you got March hanging right over your head. So that's going to be added on to this.
Right. Okay.
All right. I can adjourn this out a week for you to think about it and contact plaintiff's counsel. I should actually adjourn it out. You can also, have you tried applying for any assistance at all?
No, I haven't. I got the paper in the mail on Friday, so I still have to look over that and look at some things. It's some
Okay,
resources.
I'll
on
give you
here,
an
though.
opportunity to do that. I don't have now available, Ms. Dornbush, I don't have March 6th, so I'm going to give her an adjournment to the March 13th, 2026 at 12 noon. Okay?
Okay.
Look that over. Ma'am, if you're going to apply for any type of assistance, there's a form that's also in your packet called a rental assistance form. You'll need to fill that out and get that to the court by Wednesday of next week.
Okay.
Okay?
Okay. Thank you.
Thank you.
Okay.
Silo Farms versus Alicia Clark.
She's here.
Alicia Clark? Oh, there she is.
Yes.
Okay, hello.
Hi.
All right. And what is the claim in this case?
Your Honor, with court costs, $11,010.81.
11,010.
$10.81.
Got it. All right, Ms. Clark. How are you intending on getting this paid?
So I just have a couple questions. I'm gonna apply for some assistance, but I was in bankruptcy until it was just discharged, and the attorney called me on the 31st of December, and then I got notification, like I think on the 2nd, of course, because of the holiday. And then when I got this paper, it had said that she had sent me something in January, but I checked my informed delivery and everything. I never got anything at all. So I called my bankruptcy attorney because I wasn't for sure, like, is all of this like after the September 29th amount?
So, Your Honor, with the bankruptcy discharging, the pre-petition arrears were $2,217.48. This balance, the $11,010.81, takes into account that discharge. So that's been removed from the ledger balance, and the $11,000 balance I stated is everything post-petition.
Oh, can you say that one more time, Miss Rachel?
The
Sorry.
number? Yeah,
Yes.
the number is $11,010.81.
Okay. So my hope was to pay this today, but I actually got notification in the mail that I had to verify my identity with the IRS because of fraud.
Got it. Okay.
But yeah,
let me ask you this, ma'am. So you think that you're going to be able to pay this plus your March rent once that verification comes through?
Yes, because I did the verification yesterday. It said it was all done. And I reached back out to them to make sure. And then in the interim of getting this paperwork last week, like the next day I got something in the mail because my lease is actually up on the 31st of March, and it said that they were not going to renew my lease, which I was kind of baffled by too, because I talked to the property manager prior to filing the bankruptcy, because I had to do it in order to be able to get the home loan. But the home loan for Heroes, they said I can't do it until December 31st of this year because of the extenuating circumstances, and I have to wait a year. So I was kind of shocked because, of course, I don't have.
Why don't you talk with them again All right, I don't, sometimes, and I don't know in this case, but as to why that might have been sent out and what their intention is on that. All right?
Okay. Mm-hmm.
So here's what I'll do, ma'am. I'm going to adjourn this to March 13th, 2026 at 12 noon. That's an in-person hearing, so you'll need to come down to the courthouse unless you get everything paid, okay?
Okay, so it's adjourned until March 13th at noon in person.
Yeah. Yes, ma'am.
Okay.
All right. Thank you.
Thank you. Mm-hmm.
Scio Farms versus Lauren Eccles. Oh, there she is. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $650.05.
So I paid 718 yesterday.
Your Honor, I can check with Patty. I don't think Patty signed into Zoom this morning.
Okay.
And so I'll verify with Patty. If we want to just adjourn it over to the March date. If it was, in fact, paid, then we would submit a dismissal and deal with March separately.
You got that, ma'am?
Yes.
Okay, so I'll adjourn it March 13th, 12 noon. Okay? Thank you. Style Farms versus Ayana Gatewood.
Not checked out.
Ayana Gatewood. No response. You'd like to, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Pallets Law, on behalf of plaintiff. There is rent to retain of $2,084.05. Costs are $192 for a total due of $2,276.05. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession, redemption amount in the amount requested. Writ to issue in 10 days. Scio Farms versus Tyler Kroll. Tyler Kroll.
Yes, sir.
Okay, there you are. What is plaintiff's claim?
With cost $2,374.02.
Mr. Kroll, how are you intending on getting that paid? Did he freeze on me?
Yeah, it looks like.
Oh, he's back. Mr. Kroll?
Yes, sir.
How are you intending on getting this paid?
Yes, sir. I actually have the money. I got to wait for my ID to come in the mail so I can do a bank account. Because my bank account closed. So after I open my new bank account, I can cash the checks and I can get it paid.
Got
I
it.
applied for a new ID
Okay.
last
So
Friday.
you have the money,
And they
you just
told
need an
me-
ID.
Yes, sir.
All right. So I'll adjourn this out to March 13th, 2026 at 12 noon. Can you type that into him also because he's breaking up? I want to make sure he's hearing. Okay, sir. So we'll see you in person on that date.
What date?
March 13th at 12 noon.
Okay, and if I paid before then, you have to come?
If you paid everything before then certainly you don't need to appear, but you're going to have March rent click in. So you got to make sure you paid this plus March rent.
Yes, I appreciate it.
Okay. He froze again. All right. Thank you, Mr. Kroll.
Thank you.
All right. Scio Farms versus Maria Mlota. Yep, she's here. Ms. Mlota, can you? Yeah, she's She'll get it in a minute.
Okay, I'm here.
Hello, Miss Enloza. How are you?
I am doing okay.
All right. All right, Ms. Dornbush, how much is owing on this?
With cost $2,307.19.
Okay, Ms. Enloza, how are we gonna get this paid?
It's really bad. So far I was not feeling well, but I got scammed in November. So the bank reversed the fees back to me, even though I didn't even, use the money. It's the scam. I applied for a loan to pay my bills, all my bills, because I like when I start the new year to start with 0 bills. Instead of getting, 5,000, I applied for a loan from Advance America. I ended up getting scammed. So the bank ended up, reversing all those fees to me. And then January, they garnished my Social Security. And then plus they added more fees. So it inconvenienced me a lot because now it's like paying back. It was really bad. And I feel bad for Sayo Farm because I didn't pay them anything and I don't have any money. So hopefully March I'll be able to.
Ms. Young, you understand that you are entitled to have a hearing
Yes, Your Honor.
and you wish to waive that hearing and admit to the violation.
Yes, Your Honor.
All right. Look, this is not complicated. How old are you?
I'm 23 years old, Your Honor.
23. Is this truly how you want to spend the rest of your life, in and out of jail, in and out of court, in and out of looking for your next drug? I mean, it just, to me, you're wasting your life. We're trying to help you here. So there's a couple of things. I'm going to continue you on community control this time. I'm going to put you in Judge Pillar's recovery court. I'm going to order you to complete the IOP with recovery housing at the coach. I'm going to place you on electronically monitored house arrest. Now, you have 260 days jail time credit, which is you're coming up on about, what's that, about 9 months. Your next violation, I'm going to send you to prison. And again, that has to be a motivation for you, I would think. Now, I understand you're seeing someone that you met in recovery is he in active recovery or active addiction?
We're not in a relationship, Your Honor.
Okay. You are not to have contact with people other than Judge Peeler's recovery court.
Mm-hmm.
You're not to have contact or see anyone who's in active addiction.
Of course.
The other thing is, I'm going to hold you in Warren County Jail because you've never stopped smoking marijuana. It was one of my orders. You don't understand. And again, the THC level in today's marijuana is so high, it is harmful to your mental health. It is harmful to your physical health. And it's not helping you in your recovery from your addictions. So if you continue to use marijuana, that's fine, but you're going to stay in the Warren County Jail until you can produce a negative drug test. We're clear on that?
Yes, sir.
So Officer Sukavecki is going to test you today. If you're negative, you're going to get out. You're going to get out today and go to the coach. If you're positive, if it's still in your system, she'll be back next Friday, and it's just going to cost you a week at a time. So either stop smoking or suffer the consequences. But I'm just telling you, it's not helpful to you. It's hurting your life. Let's get control of your life now, okay? I'm trying to give you this opportunity with some severe motivation hanging over your head. I don't know what else I can do except to threaten you, and I try to help you here. And if you don't want to take the help, that's your choice. But I just think you're missing out on a great deal of life by making these poor choices. Ms. Tranter, is there anything else?
Nothing further.
Mr. Gibbs?
Nothing further.
All right, that's all. Good luck.
Thank you, Your Honor.
here. We'll do the two Colden Ponds second. We've got three others that are, here's Sarah Reed from Payless. So we can address that case.
And, I don't know if you got the paperwork or not, but Attorney Reed and I have worked out resolution on one of the cases.
Which one?
Brianna Ellsworth.
Oh, all right. Very good. Good morning, Ms. Reed. Welcome back to Centerville on a Friday morning. I'll call your case. It's Three Rivers Village versus Brianna Ellsworth. Manager Lois Holloway is here. Meg Bauer is here on behalf of the defendant, and you're here on behalf of the park. Meg just informed me that you guys have worked out a resolution. What's the status here?
Thank you, Your Honor. I did email over to the clerk's office earlier. So what we've agreed to do, of course, obviously, if the court is amenable to it, is we've done a dismissal as to Ms. Ellsworth from this action, and then just did a judgment as to all occupants. I explained to Ms. Bauer, this is something we frequently do in 36th District Court in Detroit, are all occupants judgments. So the all occupants judgment just indicates that the writ can issue after March 9th. There's no redemption amount. And then Ms. Ellsworth is dismissed from the case. And obviously with the agreement that she's going to be out by March 9th, which is something Ms. Bauer and I have agreed to earlier this week. So that way Ms. Ellsworth is protected from not having a judgment on her credit report or anything to that nature. And it still provides us with a judgment if and when we need to execute the writ.
Interesting. I have yet to see one of those. Meg, do you see those from time to time?
I've done variations on a similar arrangement when we're trying to bifurcate, kind of like in the Donna Carr case. I know you see a bunch of cases, but when we've got those unauthorized occupants that are problematic. So I've done similar things. In this case, the defendants are all but moved out already. So we're not opposed to this kind of arrangement. It doesn't have a judgment in the tenant's name.
All right, very good. All right, I haven't seen that yet, Ms. Reed. Elaine, I don't know if that's in the pipeline somewhere, but I will note that dismissal order is coming. And judgment as to all occupants. Very good. I don't see Mr. Davidson. Here he is. Ms. Reed, is that your only case for this morning?
It is, Your Honor.
All right, thank you for your help.
Okay.
I'll find that order and execute it, and here it comes.
Okay, do you want me to stay on while you look at it?
Yes, thank you. I'll execute it. You're good to go. Enjoy the rest of your day.
Okay, thank you. You as well. Thanks, Meg.
Yeah, thanks, Sarah.
All right, Ms. Holloway, I guess that resolves your case, so you're good to go also.
Thank you, sir.
Next is McDaniel versus Suter. No, that's not the one I want. I want that's Ellsworth. That's the wrong case. I want Myers versus Villock. Mr. Matthew Davidson is here on behalf of the plaintiff. Good morning, Mr. Davidson.
Good morning, Your Honor, and I'm sorry if my volume's low. I'm still trying to fix that problem.
It's not too bad.
Okay.
Miss Villock told us that she was going to be moving out expected to be out. She's not here this morning. Do you know what the status is?
I've been told that she moved out. We were hoping she'd still show up today because we had some questions for her. She did not bring keys to my office, and I don't know if she left a forwarding address or not. I have to check with my client. Who I thought.
All right, well, let's see. There's two people in the waiting room. See who just showed up. Ms. Myers, Ms. McDaniel. Why don't you go ahead and send me a default judgment?
I'm pretty sure there was one in the file.
I mean, look. There it is.
Thanks, Your Honor.
All right, what we determined was a little out of date. What's the current arrearage?
Oh, shoot. I wasn't ready for that. I'll send you a judgment.
All right. I've got a stale one, which was $4,864.22. That was $190 per week, and it's several weeks in arrears. So
I think it's just 2 more weeks. Is that right, Mr. Meyer?
I think that's right, at $190 per week. So we'll add, the rent is $4,397. 4,397.77 plus
everything
380
Sorry, everything else should be the same.
is 4,777.77 through today. Court costs are $186.45. You got $280 in late fees plus 2 more, so that's $320 in late. Plus court costs of $186.45. Is $5,284.22. As a practical matter, she's not going to pay that if she's vacated, but theoretically she could. We don't. Mr. Mayers, do you have the keys back or hear anything from her?
I do not.
All right, we'll go ahead and do this default judgment. The date will be March 9th. All right, very good.
So I can't take possession until March 9th?
If she's vacated, I'll put in here, if defendant has vacated, plaintiff may take possession.
It was our belief that she had, Your Honor.
All right. We did give her explicit instructions on what to do with the keys and the forwarding address. And so I don't know, we'll go ahead and enter the default. And I indicated plaintiff may take immediate possession if tenant has vacated. Thank you, Mr. Davidson.
Thank you, Your Honor. I saw Steve Lee the other day and he told me to say hi.
I ran into him a while ago. It's been a long time, but all right, thanks.
Yeah, I saw him at Gibby's.
Okay. All right, thank you. I'll see you later.
Have a good weekend.
Mr. Mayers, you're good to go. I got a couple more people to admit.
Thanks, Your Honor.
Thank you. Mr. Mayers, I'll move. All right, next up, we've got McDaniels versus Suter. Let me remove Mr. Mayers.
It's fine. You gotta be here.
Dawn McDaniel versus Ashley Suter. We determined there's no lease. We had a previous hearing on February 9th. The defendant indicated she was going to be moving. Ms. Suter, what's your current status?
I've actually been working on trying to get a place for the last 2 weeks, and I've been hounding the people who own the home every day, and I still haven't heard nothing back. He did contact me the other day and said he should have had an answer yesterday or the day before. I messaged him again today, and I still have yet to hear about it. And I'm actually filling out paperwork for an income-based apartment.
All right, that's good too.
Oh, I'm not slacking over here. I'm trying to get out because this is a whole messed up situation and there's more to it than what you're being told.
There almost always is. Well, let me repeat. You have 10 days to vacate from today, which will be March 9th. No money judgment is entered. You also have until March 9th to appeal this.
Okay, so with how I brought it up last time, how do I go about the propane tank? Because the agreement was between Ryan and I need Ryan to be here in order for them to come get the tank and reimburse me the money that I paid for.
This doesn't have anything to do with that. It's simply, you've got 12 days to move.
Okay, I just don't know what.
If there's an issue regarding the tank or who owes who how much money, you can sue them in small claims court or take it up with Brian McDaniel. But Dawn is also an owner of this property.
Yeah,
when
just
you move,
recently.
you need to turn in your keys and give your forwarding address in writing within 4 days.
I will be getting a PO box because I don't want that lady to know where I live. So.
All right, fair enough. That's what triggers the security deposit law. At this point, I'm not ordering any money damages. After you move, she could file an action for money damages. And if it goes to the PO box, so be it. But I'm not ordering that you pay any money. Now you get 2 extra days because there's a weekend in there. So this actually is 12 days to vacate. Now, Ms. McDaniel, you don't have to evict her exactly on March 9th. You have 56 days from today to seek the writ of eviction. So if she's got a moving van backed up there on March 9th, it might not make a lot of sense to do an eviction. But if there's nothing going on and no action is being taken, you can bring $15 to the courthouse and they will assist you in securing an eviction where the sheriff puts her out. Ms. Suter, I'm sure you do want to get out of here and people would move.
I do.
And they tell me, I'd move if I had a place to move to.
Yeah,
So
and that's what I'm working on at the moment.
All right, I hope it works. Either one of you have any questions?
Nope.
All right, you're both good to go. Thank you.
Thank you.
All right, next we are down to our 2 Golden Pond cases. We've got Mr. Cromendike, we've got Ms. Villa, the manager, we got Meg Bauer, we got each set of defendants. So let's set Millerans aside for a minute and we'll address the Cantrell matter. Good morning, Mr. Cromendike.
Good morning.
We're actually not in too bad a shape.
And Your Honor, Meg and I emailed a bit back and forth this morning about the Cantrell matter, about a possible conditional dismissal. And so I'm wondering if it would make sense for us to jump into a breakout room to discuss terms of that with the property manager a minute.
Sir, I don't have a problem with that. Meg, you agree with that?
Absolutely. And thank you,
I'll
Judge.
put Meg, Casey, and Steve in a breakout room. And
And Judge, I think unless Attorney Cromendike objects, I think Ms. Cantrell could be part of this conversation as well.
Yeah.
is that okay?
Yeah, I'm good with that.
All right, I'll put everybody in there. Everybody join the breakout room. All right, the Milleranses are in the waiting room. This next case is theoretically a status conference, and there are lots of issues in there. The other case, and as soon as they finish, I'll bring you back from the waiting room.
Okay, thank you, Your Honor.
Mhm. All right, I'm just cleaning things up here, taking things out of the queue.
Heather, after he pays the 447B, he's to pay on 222B. And then and I'm going to reduce that balance. Boy, you really made a mess of this. You know that? Reduce balance from 327. I realize he owes a clearance fee to 250, but he still has to pay the clearance fee.
Okay.
And then on 222A, we'll pay 125 per week until paid in full. In other words, just print them out. How did that get to such? Anyway, 325, 125 per week after fines costs paid on 22B. Okay? You understand? Now, let's say you don't have the money on any of these occasions. It's not a problem. Just call the court. We'll go on Zoom. I'll be glad to give you an extension, but don't ignore us anymore. We got each other?
Yes.
All right. Good luck. Thank you. Good luck. Do we have Flat Rock out there or state police out there?
Yeah, they're ready.
John Lawrence Wood, 26M 703 415. Good morning, Trooper. Your name?
Good morning, sir. Sergeant Evan Rizeppa, Michigan State Police.
All right. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
Yes, sir.
Okay, go ahead.
All righty. In front of me here, I've got a report from Trooper Brown swearing on behalf of him. On Monday, August 4th, 2025 at approximately 9:10 a.m. in the county of Wayne, South 75 at or near West Road. Trooper Brown, near this listed venue, paced a vehicle for 85 miles an hour in a 75 mile an hour zone and also observed illegal window tint on the vehicle. Driver was identified as John Wood, and it was discovered that the vehicle also did not have insurance on it, and narcotics were located on the Wood person. Narcotics were seized and submitted to the MSP lab for further analysis.
And it was positive for cocaine.
Yes, sir, that is correct, based on the information in the reports received from the lab.
All right. You must have sent this over yesterday or something, right? It was dated.
Oh, I did. Yes, sir. I sent it yesterday. I'd have to look at my email for the time, but yesterday.
That's okay. I'm just changing the date on the complaint and initialing it because you'd sent it yesterday and you had the 26th on there. Based on your sworn testimony, I find that the crime possession of less than 25 grams of cocaine was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. I'm signing and dating the complaint and warrant and initialing that change. You are
put in some money. But I'm in the process of applying for DHS again because I found out that DHS, if you apply DHS with other things, they deny you. So you have to apply it separate. So I'm going to apply again. After this, I'm going there to apply again separately.
Okay. And
then
are you eligible for Hawk funding, you think, or no?
I left a message, so I'm hoping that they will call me back.
Okay. Ms. Mlota, here's what I'm going to do. I'm going to adjourn your case out to March 13th, 2026 at 12 noon.
Okay.
Okay. Make sure to turn in that paperwork if you apply through DHS, that you turn in the paperwork to the court by Wednesday.
Okay.
All right. And then hopefully if you talk to SOS or Hawk, somebody will call you back between now and then, okay?
Okay, thank you so much.
All right, thank you. Take care.
You too, thank you.
Sile Farms versus Jason Rhodes.
Good morning.
Oh, there you are. Okay, he's here. What is plaintiff's claim?
With cost $2,388.81.
Sir, how are you intending on getting this paid?
I paid that on the portal on Tuesday.
So you think everything's paid?
Yes.
All right, so here's what I'll do. I'll adjourn it out to the 13th, 2026 at 12 noon. If everything's paid and you paid it before the end of the month, they're going to dismiss the case.
Okay.
Okay. And if not, then something happened with March, but if you got everything paid, you're confident everything's paid so that it'll just be dismissed out. Okay.
All right. Thank you.
Thank you. Sile Farms versus Amanda Ridley. Amanda Ridley, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,350.91. Costs are $192 for a total due of $1,542.91. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Sile Farm versus Jesse Steenberg and Brett Steenberg.
Here, sir.
All right, there's Jesse. All right. What is the claim?
With costs, Your Honor, $1,704.26.
All right. And ma'am, how are you intending on getting that paid?
I just have to wait to go to the bank today, but I intend on paying it well before March 13th. So.
Okay. So are you saying you're going to pay that and March or?
Yes. Yes.
All right. Let me ask this so that we'll simplify things. Do you have the money to pay it now? You said you just have to get to the bank.
Correct. Yep. I have 14 and then I'm just waiting on the 300. But I should be able to pay that before the actual end of February. And then by March, I'll be paying March as well. So.
Okay. So here's that. The reason I asked that, ma'am, is I'm going to adjourn this out to March 13, 2026 at 12 noon. If you get everything paid before the end of February, then you're going to be in good shape and they'll dismiss this case.
Yes, sir.
All right. If not, then you'll need to appear in person on the 13th, and then we'll figure out this with the March payment. Okay?
Yes, sir. Thank you.
All right. Thank you. Have a good weekend.
You as well.
Then I'll recall the case of Barbara Woods versus Sarah Ellison. Did she come back?
She did not come back.
She did not come back. Sarah Ellison? All right. Well, not here. You've been sworn. You may take a default.
Thank you, Your Honor. There's rent to retain of $3,527.44. Costs are $188 for a total due of $3,715.44. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with the writ to issue in 10 days. I think that's all I have for you this morning.
Great. Thank you, Your Honor.
Thank you. Hamilton Crossing 1 versus Kristen Benson.
Good morning, Your Honor. Jillian.
Good morning. And Miss Benson. Oh, there she is. Hello, Benson. All right. What is plaintiff's claim in this case?
A balance including court costs of $2,852.
All right. Miss Benson, how are you intending on getting that paid?
I've already submitted another
money order for $1,000 to them. And that was on the 6th. And I don't think they're adding that, or maybe it was after, but I've already submitted $1,000 to them again. So I should have it all paid by the middle of March.
Okay.
Oh,
Your Honor, I
yeah.
early February of $1,000. So that
I'm sorry.
I can see a payment of $1,000 from early February payment.
Okay, but that's been taken off of this account, of this balance.
Yes, Your Honor.
Okay. All right. So, ma'am, are you going to apply for assistance or anything, or?
No. So I have already sent $1,000 again. So they haven't put that towards it. I did call the front office, but I should have it all paid off by the middle of March, March 15th.
Okay.
Okay. Well, here's what I'll do. I'll adjourn this out to my next available date of March 13, 2026 at 1 p.m. Okay. That's an in-person hearing, so you'll need to come down to the courthouse. If you apply for any assistance, you'll need to fill out the rental assistance form and submit that to the court by Wednesday.
Okay, thank you.
All right, thank you. Hamilton Crossing versus Christina Franks Hatter.
Jillian Engen for plaintiff.
Franks Hatter, I see her. I don't see her.
Hello, I'm right here. Good morning.
Okay. Oh, there you are. Okay. I couldn't see you for a minute. Good morning. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $912.
All right. And ma'am, how are you intending on getting that paid?
I wanted to pay $350 today and pay the rest on March the 6th.
You're going to pay $350 today?
Yes, I get off of work at 4 o'clock and I can make it to the bank by 4:30 and drop it in the leasing office mailbox by 4:40.
Okay. And if you don't pay all of this today, then we're going to have March added on to it when we come back on this case.
I don't pay any rent currently right now.
Oh, okay. So you're at zero.
Yes.
Well, Your Honor.
Okay. Gotcha. No, that's fine. So let me do
I want
this.
to have
Pay
it
the
completely paid off by March the 6th. That was my intention. And I had just got the letter in the mail over the weekend. I'm like, oh, I'm trying to pay it.
Okay. So you think you'll have everything by the 6th?
Yes, I certainly will.
Okay. So here's what I'm going to do. I'm going to adjourn this out to my next date, which is the 13th, 2026 at 1 p.m. That's an in-person hearing, but if your rent is zero and you get all of that paid, I'm not going to need to see you.
Okay, thank you so much.
All right, thank you. You have a great weekend.
You too, thank you.
Hamilton Crossing versus Tiffany Tackett.
Jillian Engen for plaintiff.
Hello,
Tackett,
Your Honor.
Hello, there you are. All right. What is the claim in this case?
I have a balance including court costs of $1,533.
All right. And Ms. Tackett, how are you going to get that paid, you think?
I have legal representation and my attorney wasn't able to make it today, so I was wondering if we might be able to get that adjourned.
I can adjourn it. Who's representing you?
Alex Henry from Legal Aid.
Okay. So I'll adjourn it to the 13th.
Okay.
2026 at 1 p.m. That's an in-person hearing. So
Okay.
let Mr. Henry know that. Also let him know that the answer to the complaint would be due by March 6th.
Okay. Thank you, Your Honor.
All righty, thank you. Have a good weekend.
Thank you. You do the same.
Hamilton Crossing 2 versus Tierra Pratt.
Jillian Engen for plaintiff.
Is Pratt here?
I'm here.
Okay, there she is. Hello.
Hi.
Okay, what is the claim in this case?
I have two things, Your Honor. Rent plus court costs totals $4,033. Your Honor, we also have a conditional order of dismissal from a previous case that is still applicable. And so I think that we might be filing an affidavit of noncompliance under the conditional order of dismissal for the previous case.
Nope.
Got it.
That's incorrect, and I will be contacting the lawyer. The COD was paid off in December, and also they were charging me late fees, and I for each month, and I already then on the account I just made a $2,600 payment, $2,684 payment yesterday, and that should be on the account. And she said that she was going to remove the late fees, and they So
hold on, Ms. Pratt. You paid how much yesterday, you said?
$2,684 yesterday.
Yesterday.
Mm-hmm. And also the COD was paid off in December, and they kept applying late fees on this on my CD each month. So I have not been in compliance. The COD was paid off in December. So what you're seeing on there is
Okay, Ms. Pratt?
Your Honor.
Yes.
Okay, right now, I don't see any of that, right? 'Cause
Well,
I
she
just
should
have
be
this
able
in
to
front of
see
me.
it.
Okay, ma'am, hold on a moment. Here's what I'm gonna do. I'm gonna adjourn this to March 13th, 2026, 1 PM. Bring all your that's an in-person hearing. Bring all your documentation and everything. By that time, your payment should have caught up. Your March rent will click in. But then if they file the affidavit, I can also take a look at that case and make a determination as to what's happened on it, okay?
And then I shouldn't even have no legal fees, because I just talked to the manager yesterday, and she told me that they were going to dismiss this, but I showed up just in case because I knew it was going to be some drama. And I'll have my lawyer reach out to them.
Well, there's no drama yet. I'm just, everybody's just
like
telling me
they just
their
not doing
thing.
what they supposed to do, and then have
Well,
me with
ma'am,
court
Miss
fees.
Pratt, I've listened to you. I told you there's nothing I can do right now because I don't have all of that in front of me.
Okay.
All right. So I've set it out 2 weeks at 1 o'clock. You say you're going to get an attorney. Let them know when that is.
Okay.
And then everybody will be here. The account should be at least reconciled. I can take a look at everything and tell you where it is. But you're just talking at me right now. I can't do anything about it.
I know. Thank you. So you said,
Thank
and
you.
when is it? So I can be clear, because I was over
March
talking you, and I
13th.
apologize.
March 13th, 1 o'clock.
Is that in person or is that
That's
Zoom?
in person.
Thank you.
Okay. And if I can't do in person?
Well, you can file the Zoom request, but I don't know how you're going to get the documents and everything to me. So I'm setting it in person. You can file the Zoom request, but it may not be granted.
Okay. I'll try to get the day off.
Thank you.
You're welcome.
Hamilton Crossing 2 versus Coyote, is it Ayodele?
Yes, I'm here, Your Honor.
Okay. And also the other Ayodele. I'm not even going to try that first name. All
That's
right.
my wife.
Sir.
I do. That's my...
All right. Okay. What is the plaintiff's claim?
Jillian Engen, Your Honor, the balance that I currently have is $3,228 in costs, but my client is looking at the rent being assessed. I just a brief overview of the issue. whether or not rent can be increased, if there's an income change for, I think I'm sorry, she's here so she can correct me if I'm wrong. She's the property manager. But there's a question as to whether rent can be adjusted in the interim during a lease period when tenants' income changes. And so we're going to be looking at this and getting her an answer so she can get a final number for the rent. And so, Your Honor, we're just relating to adjourn this. Like, is what
okay. And I should say, is it on under Anke? Ma'am, help me with it. Give me your name. I see you up there.
It's
Got it. Okay.
I prefer
So,
Adi.
All right. What I'm going to do is I'm going to adjourn this out to the 13th of March. They're going to be taking a look at your account, and then we'll figure out where we'll go from there on this. Okay, folks?
You said March 13, right? What time?
Yes, it'll be March 13th, 2026 at 1 p.m. That's in person here at the courthouse.
Okay. Thank you.
Okay, they'll get your account reconciled, look at what they're going to do, and then we'll have a number, and then we'll figure out how we're going to work this through. Okay?
Okay, thank you.
Thank you, Your Honor.
All right, thank you. You guys have a great weekend.
Have a good weekend too.
Hamilton Crossing 2 versus Jessica Jackson.
Jillian in for plaintiff.
Oh, there she is. Miss Jackson's here. She's just trying to figure out how to unmute. All right. Hello, Miss Jackson.
Hello.
All right. How much is owing on this?
Your Honor, I have a balance including court costs of $1,440.
All right, Miss Jackson.
Yes,
How are
sir.
we going to get this? How are we going to get this paid?
Couple weeks.
Okay. You can get that in March, you think, or?
It won't be in March. It'll be that. I guess I calculated wrong and I thought it was 12 that I owe. I'll be able to give 500 on Tuesday. And then the following Friday, I'll try my best to get the rest.
All right, so you're going to pay 500 by the 3rd. I think, yeah. So you're going to pay 500 by March 3rd. And then you think the balance you might be able to have by the 13th, but you're not sure. Okay.
Right.
Let's do this. Then I'm going to adjourn it out to March 13th, 2026 at 1 p.m. That's in person. If you have everything paid, I don't need to see you. All right. But if not, you'll have to come down to the courthouse. We'll figure out where to go from here. Okay.
Okay.
All right. You have a great weekend.
You too. Thank you.
Hamilton Crossing 2 versus Tierra Warren.
Jillian Engen for plaintiff.
Miss Warren, hello.
Hi.
Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including of $1,046.71.
All right. Ms. Warren? How are we going to get that paid?
So I'm just trying to understand where she got that balance from, because on the judgment I was 721 by February 8th. I've made in January I only owe $52 left. And I made a payment of $400 yesterday. So I'm not understanding. And when I called and spoke to Daryl at the front desk, he said I only owed $800 and some change. And I paid $400 yesterday. So I'm trying $400 in total. So I'm just trying to understand where she got this balance from.
Your Honor, if I may, I can answer this part of that. So part of that is, Ms. Warren, when we get the ledgers from our client, because it's in the morning, we ask for them the day before. And so I wouldn't have that $400 payment, so I can make a note of that and it would be reflected next come back to court. The other thing is on your ledger doesn't yet reflect court costs, but the court costs are $176.
Yeah, but I shouldn't have a court cost because if it said on the paper, it said that the judgment was put in at the end of December 31st, which I shouldn't have, my rent was paid through January. I owed $52 in January. That was it. Then February came out. I paid $200 on maybe the 15th of February, just gave another $400 yesterday. So I shouldn't have court fees either because it wasn't not paid through December 31st. And that was on the judgment because the original paper said I owed $721.
Well, ma'am, this isn't about the judgment. If you look at the complaint that came in this case, they indicated that you owe $1,130.81 as of February 11th.
Okay. Well, yeah, I don't even owe that.
Okay, but if you owed something in February, then they're entitled to their court cost.
Okay, well, that's fine. But then, so how much do I owe? Because it shouldn't be the 1,000 or whatnot. Because when I called and spoke to Daryl, he said I only owed $800 and something. And I gave $400 yesterday. That's why I was coming here to clear up everything and make sure, because I can make a payment today and I want to pay it off, but I'm not trying to give extra money. I don't have money to just give.
Okay. Nobody's trying to give extra money. I get you.
At all. And I tried to call and speak to Jillian on Monday. I called and left a voicemail, never spoke to anybody. I called to the rental office since Monday, never got a call back. So communication is horrible, but I don't have money like that. Like I'm a single mom of 2 kids. Like I don't have money.
Ma'am, Miss Warren. All right. I don't know. I had the balance I was given was the $1,046.71. The problem is you paid something that's probably not taken off of that figure. That's what counsel was indicating. So what you paid, you'd subtract that out. I think where the difference for you is going to be in the court cost. It looks to me like they would be entitled to the court cost. So I think you're going to have to pay that. So let me ask you this, Ms. Warren. How much can you pay today?
I guess I want to know exactly how much I owe, because I don't want it to go
okay,
over.
Ms. Warren, I'm not going to go around in circles.
Okay, $400. I can give the $400.
Okay, so here's the thing. Pay the $400 today. Okay, it looks like you're probably going to owe more than that, but I'm going to adjourn it out 2 weeks to the 13th. Okay. And then we'll be able to reconcile your payments and all of that into your account, and we'll figure out a way to get you back to zero. Okay?
Okay, thank you.
All right, so I'll adjourn this out to March 13th, 2026 at 1 p.m. All right?
All right, thank you. They're so fucked.
Whoa. Oh, really?
I think
really?
It was timely, Your Honor. She muted timely.
No, she didn't.
I think thing out, I think.
You see, okay, so mark that file. We'll have to talk with her when she comes in. All right, let's go on. Hamilton Crossing 2 versus Lawrence Sharp.
Jillian Ingen. Sorry.
Go ahead, I'm sorry.
Jillian Ingen.
Okay. Okay, we'll do it this way.
Mm-hmm.
Lawrence Sharp, Ann Underwood, and Levy Sharp. Go ahead now, Miss.
Jillian Ingen. Sorry, Your Honor.
No, it's okay. It's probably my fault, but there we go. And I think, who do we have? I think Underwood. Hello, you guys want to identify who you are? Can I hear them? Can they hear me? I cannot hear them.
That's Ashley Womack.
Ms. Womack.
I'm not.
Miss Womack. No, I got Miss Womack. I haven't called, ma'am, I haven't called your case yet. Okay, so hold on a moment. I see Ann Underwood listed. I see a gentleman that may be, you're Ann Underwood, you're waving at me.
Yes.
And I'm Lawrence, Your Honor.
Got it. Okay, now I can hear you guys. Okay, I couldn't hear you before and I was a little bit worried. All right, what is the claim in the case?
Your Honor, this is a termination of tenancy case. Mr. Sharp is a former employee who took possession without authority, or the application was approved before a lease was signed. And Your Honor is requesting an immediate order and in this matter under MCL 600-5744.
All right. You guys heard that?
Yes, Your Honor.
All right. What's your position?
Well, Your Honor, some of that is correct. I am a former employee. I was an employee
Until they came here with 9 people threatening to move out.
and, I did the paperwork as anyone does, and I waited. Our lease was up, so I already had the U-Haul packed from our last apartment, waiting for the okay that I was approved. It took about 5 or 6 days. Finally, I got to go ahead and said I was approved. Now,
so are you going to move out?
No, we don't.
I really would like to stay here. I have the money to pay and everything. I don't.
We don't want to do any more damage.
I hate to move my son around again. He's only 11, and I just don't understand. I moved in a day early. After I got the verbal say that I was approved, I didn't steal any keys. I had the keys because I will have access to check apartments and stuff. I was told to make sure it was move-in ready. So I did that. I did move in before I paid my security deposit, but there was no one in the office by the time I had the money order. So I was just going to give it to him the next morning. I figured no harm, no foul. And then this happened, and I got fired on top of it. So it's been a rough couple months, Your Honor. And all I'm trying to do is take care of my family. And I'm sober. I've went through all this stuff. I've been clean. I'm going to college. My family actually likes this apartment.
Okay.
Yes,
sir.
Yeah.
It sounds to me like you may have to vacate the premises. I will give you an opportunity to speak with a lawyer on this.
Yes. Thank you.
I'll adjourn it out to March 13th, 2026 at 1 p.m. But you need to also understand that if I grant them a judgment on that date, that there will be an immediate writ. So there's not going to be like it goes out to then and then you get additional 10 days.
Right. I understand.
My suggestion to you, you can talk with an attorney. My suggestion to you is that you might want to make arrangements to get yourself to another spot.
Right.
So that you and your family aren't out.
Sure. Yes. I'm actually already on top of that. I mean, we do like this place, and I would have no problem paying, but if they want me out, then I'll have to, get out, I guess. But
I think, sir, that's what they want. That's why we're here.
Okay. All right.
But I have to give you an opportunity to speak with an attorney. Okay.
Okay. Thank you, Your Honor. I appreciate it.
Thank you.
Thank you, Your Honor.
Strong Future Homes versus Susan Farley.
Jillian Engen.
Susan Farley, not checked in. I don't think you've been sworn.
I don't think so.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Thank you. This is a case for non-payment of rent. Rent retained possession is $2,094. Court cost for $176 for a total of $2,270. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10.
Judgment to the plaintiff, that's by default. Possession, redemption amount in the amount requested, writ issue in 10 days. Strong Future Homes versus Ashley Womack.
Jillian in for plaintiff.
She is here. Okay. Hello, Ms. Womack. All right. What is plaintiff's claim?
Your Honor, I have a balance including court of $2,115.28.
Give me that last, I had 21 and then what? You broke up.
$115.28.
Got it. All right. Ms. Womack, how are you intending on getting that paid?
I just found out 4 days ago that I owe this. I'm low income. I guess I messed up on my recertification. I don't know why it keeps going up because my recertification is in. Last out, my court papers say 1,900 and something. So my recertification has been in for like almost a month now, or at least 2 weeks. So I need to figure out why the reason is not in and my rent keeps going up.
All right. So you think there might be a recertification issue?
Yes, and then the balance I can get help with, I guess, from SOS, but I don't know why it keeps going up.
All right. So you need to apply, if you're going to try to get assistance, apply to SOS. Okay. And then what I'll do, and if it's a recertification issue, what you might want to do is contact legal services, see what's going on. Okay.
Yeah, because my rent is usually zero. So.
Okay.
And
so what I'll do, ma'am, is I'm going to adjourn it out to the 13th of March, 2026 at 1 p.m. That's an in-person hearing. All right. But don't wait to the last minute to reach out to
SOS.
To SOS. Okay.
Thank you.
And
all right. Thank you, Ms. Womack.
Really briefly, Your Honor.
Yeah.
Rent changed in January, and so it's for January. If the recertification was, then it might be that it takes effect in March. And so I know my clients, I'm sure my client's working on getting that process, and hopefully we'll have updated final numbers here.
And I'll get help with the 2 months, so that way it can be cleared.
Thank you.
All right. Thank you. All right. Thank you, folks. Ms. Womack, have a good weekend. And Ms. And you too.
Thank you.
All right. And Miss Dorsey was on here shaking her head at my ruling and letting people have time. That's okay, Miss Dorsey. You don't think I saw you. I saw you the moment I said somebody's getting the adjournment. You're like, oh. And I said, well, at least she's muted and not yelling at me, so I'm good. All right. All right, you guys take care.
Your Honor, she's got a camera on.
Yeah. All right, you guys take care, and court's going to stand in recess.
Thank you.
Thank you.
A preliminary here, a pretrial hearing that is with Judge Bond at Tucson City Court. This is also your arraignment in that case, so I need to let you know that if you fail to appear, a warrant can issue for your arrest. The hearings can go forward without you, including your trial, and if you are found guilty and fail to appear for sentencing for 90 days, you can lose your right to a direct appeal. Do you understand, Mr. Bell?
Yes.
I will enter a plea of not guilty on your misdemeanors. You are presumed to be innocent, and that is all for today.
That's why.
Did I mark the PD? Thank you. Where'd it go? Please state your name, sir. Mr. Escobar, this is the time for your initial appearance. You're here this morning on charges of aggravated shoplifting and organized retail theft. These are felony offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. It is ordered appointing the public defender's office. And we are going to determine your conditions of release today. I have reviewed the interim complaint, which describes the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services. That lets me know whether you have any prior felony convictions. It also lets me know what information you were able to provide regarding your ties to the community or any references, as well as their assessments and their recommendations. Finally, I have reviewed the prosecutor's recommendation. They're asking that you be held on a bond of $2,500. Would the state like to be heard further?
No, Your Honor, thank you.
Thank you. And defense.
Yes, Your Honor. Considering the nature of the offense, how he scored 3 points on each scale, the nonviolent nature of the offense, no prior felony convictions, I think supervision under pretrial services is appropriate.
I think I have different criminal history information. I want to make sure I'm looking at the right.
Oh, I'm sorry. Wait. Mr. Escobar. I'm sorry. No prior violent convictions.
Okay.
Yeah, my mistake, Your Honor. Sorry about that.
That's okay. I am going to order, sir, that you're held on a bond of $1,500 cash or secured. If you are released, you'll be released to pretrial services, monitoring your treatment as directed by pretrial. No alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim, and do not return to the incident location. Your preliminary hearing will be on March 19th at 1:30. No, that's not right. It's March 9th at 1:30. That court date may change. It's very important to make sure you're aware of your court dates. If you fail to appear for any future court dates, a warrant can issue for your arrest. Do you understand, Mr. Escobar?
Yes.
That's all for today.
Escobar.
She is pregnant with her 5th child at this point in time. Is going to be due later on in the middle of this year. She's also graduating from Labette County Community College in May. She has a lot going on right now. And again, she is working closely with us to get her license back. Speaking to Mr. Dean, we would need to pass this past the May 18th date. Mr. Dean has no objection to that. So we're asking for a continuance past May 18 of 26, Judge.
And I understand there's no objection from the state, Mr. Dean?
No objection. Time charge to the defense, obviously.
Yes.
For the reasons already stated, Your Honor, I believe they'll have her license cured. This is not a case that's been around that long. And I think just given them that time frame, we ought to be able to get back here after that date and get this matter quickly resolved.
All right. Missy, what do you have?
I have June 5th at 10 o'clock.
That will work.
All right, Ms. Houghton, this is continued at your request till June 5th at 10. You must be back here with counsel ready to proceed at that time.
Thank you.
Okay, we'll be in touch, Samantha.
All right, thank you.
Ms. Houghton, have you had your picture and prints taken?
I believe so.
Looks like you did post a $1,500 bond on June 29th of 2025. I will continue you on that bond with the added condition that you reappear as told. Thank you. You may go.
Judge, could we take up Mr. Darlington, Matthew Darlington?
We're on the record in GW 2025 TR 526, State of Kansas versus Matthew Keith Darlington. Please announce appearances.
Your Honor, State of Kansas appeared by and through Assistant County Attorney Paulie Dean.
Your Honor, Blake Cooper on behalf of the defendant Matthew Darlington, who appears in person by Zoom.
And how does he wish to proceed?
Judge, we're asking to continue this matter to the April 24, 2026 docket at 10 a.m. Mr. Darlington has
Your Honor, this is one that he took over, obviously, from Mr. Paul. Mr. Paul and Mr. Darlington had already made applications to restore his driving privileges, but it's not made it all the way through the state system yet at this point in time. So state does not oppose.
That's correct. Thank you, Mr. Dean. I was reading through my notes. We are waiting on a restricted driver's license application. Thank you, Judge. Thank you, Paul.
All right, I'm going to continue this at Mr. Darlington's request to April 24th at 10 a.m. to get his license reinstated or whatever the goal is, but I will likely not do it again. So Mr. Darlington, make sure you know what you need to do in this interim. All right, if there's nothing further, we'll be in recess at this time.
You understand, Matthew? Did you get that date? April 24th at 10 a.m.
Yeah.
Okay, thank you.
Yes, sir.
All right, who do you want to take up next?
Paul, have you heard back on Mr. Armstrong yet?
Oh, I haven't even got it to them yet. Also got sidetracked.
If not, Judge, could I have a breakout room with Ms. Allen while we're waiting on some information from Mr. Dean's assistance on Mr. Armstrong?
All right, very well. We'll be in a brief recess.
Thank you, Judge.
You need a breakout room for someone?
Yes, it looks like they're putting me in with Ms. Allen.
Is she the one in the jail?
Yes.
Okay. Thank you, Missy. If you'd do that, please.
And Judge, we may have to move Mr. Darlington further back on the docket. It just depends on how quickly my office can get that information determined.
Okay, well, if you need more time, just let Missy know.
And I let Blake know in the future that if he has insurance, proofs of insurance, et cetera, to CC the Jessica and Arlene so that they can be running that.
Did you get kicked out, Sierra?
Yeah, it kicked us out.
Okay, let me try again.
Thank you.
Mm-hmm.
Missy, I still haven't gotten that screen figured out from when they moved it the other day.
Let me come see if I can fix it.
Okay, I can't remember where we had that situated.
But you have to turn the video off because I don't want to be on YouTube.
Ah, come on now. Okay. But thank you for that information.
Let me try it this way instead of me talking to myself with my mic muted. Your Honor, I don't actually believe we're having a trial at that time. That case had been set for a trial previous, and then the person decided they would try to get their license reinstated once they understood the situation better. So I'm hopeful today we can verify they have a license and we'll be done with that and do a plea.
Sounds good.
In fact, I might go check and see if they got that done on the driver's license status while we're waiting.
Thank you.
Do we have anybody else here who's not represented by Mr. Cooper we can take up? Because I believe Armstrong and Allen are your last two remaining cases, correct?
That's it for me, Paul, and I don't see anybody. Yeah.
Well, there's a Williams that looks pro se, Albert Dion Williams at 10.
Yes.
And it's past 10, so we'll be on the record in GW 2025 TR 594, State of Kansas versus Albert Dion Williams. Paulie Dean for the state. Is Albert Williams here? It looks like he is. Good morning, sir.
Good morning, Your Honor.
All right, sir, you're here on operating a vehicle without registration and without insurance. And when you were here for first appearance, January 27, you were emailed an attorney application, but did you send that back?
I did not, Your Honor, because I didn't think that I would qualify, but I've had some current life events that kind of put me behind financially. So if there's a way that I can request a continuance or...
Well, are you still planning on hiring your own attorney, or are you going to apply for court appointed?
Can I apply for court appointed now?
Well, we can take a look at it. What's your current work situation? Are you employed?
I'm employed 1099.
Where do you work?
Statum Logistics.
And what do you get paid per month?
So I get paid weekly. Right now it's probably $1,000 a week.
Okay, so a little more than $4,000 a month. And what do you pay for month for rent or mortgage if you do?
$1,250 a month.
Married or single?
Single.
Do you have any minor children that you legally support?
No.
And do you have any other expenses, student loans, credit cards, bank payments?
I have a car note, credit card, insurance, phone bill.
Let's break those down. How much do you pay per month on your car payment?
Car payment is $550 a month.
And insurance payments on that vehicle, do you make them? Or is that part of how much?
$300 a month.
A month? Other expenses?
Cell phone bill, about $100 a month.
Okay. You pay utilities such as gas, electric, that sort of thing?
Gas, electric, internet.
How much per month does that all come to, do you think?
Let's say about $150.
And did you tell me you had another vehicle payment that you make as well?
Just that one car payment and the insurance.
Okay, any other payments? You said something about a credit card?
Yeah, my credit card is about $200 a month.
And you only support yourself, is that correct?
Yes. Yes, ma'am.
Anything else? Well, you have to pay food and...
Food and majority of my cost expenses go to gas for being a driver.
There you go. Well, I'm going to appoint attorney Blake Cooper. Missy, would you give me Mr. Cooper's phone number?
Yes, tell me when you're ready.
I am ready now.
316-833-1154.
And
Just
when
to
do you
be-
want? Did you get that number, Mr. Williams, or did you need it repeated?
Yes, ma'am. Yes, ma'am, I did get it, but just to verify, his name was Blake Cooper. Attorney Blake Cooper.
Cooper, yes.
Okay. Okay.
And call him. He's going to be busy on this docket for a while, but call him sometime later today and be ready to go for this case. I'm going to continue that $1,000 bond you posted. That's a cash bond with the condition that you call Mr. Cooper and be ready to go for your next hearing, and that you appear at your next hearing. And Missy's going to give that date to you right now. if she can.
Let's do March 27th at 10 o'clock.
Be back here by Zoom again, March 27th at 10 a.m. with Mr. Cooper, having talked to Mr. Cooper about your case and ready to go, Mr. Williams.
Yes, ma'am.
Mr. Dean, anything further on this matter?
No, Your Honor. What was that date, though?
March 27 at 10.
Thank you.
Your Honor, I may I ask a question?
Yes, certainly.
In the event, like if I were to just go ahead and plead guilty for the fines, will there be any leniency for, because I did get the car insurance and my registration. So would I be able to do leniency, or what my options would be?
Those are excellent questions. Mr. Cooper will want to talk to you about those and he'll tell you what he thinks you can get.
Okay.
Yes, you talk to Mr. Cooper. Mr. Cooper will talk to Mr. Dean, and those are questions. Like I said, they're good questions. Mr. Cooper will help you with all of that.
Yes, ma'am. Thank you so much.
You're welcome. You may go, sir. Okay, I think he was the only one that was pro se on this docket, this portion of the docket.
And that is basically the back of this.
Yeah. Okay, Judge, I'm not sure we have enough information regarding Miss Allen to get that insurance verified this morning. What I'm gonna suggest we do on Miss Allen. Miss Allen, I know she's from out of state, but she does have counsel. She's been held in custody on a $2,500 cash or surety since February 5th. I'm going to, I do not oppose that bond being amended to an OR bond at this point in time.
Is she the lady in the county jail?
Yes, she's the lady in the county jail. I'm going to suggest that we modify the bond, allow her to get the information. The insurance is in her uncle's name. That was the owner of the vehicle and the co-occupant when she was driving it. Because it's going to be far more helpful if we actually have a copy of the card. I think there may be one at the county jail, and if somebody could get us that, that could help speed it along. But I don't think we're going to get it resolved in this docket at this point in time in the morning.
All right, well, we'll be on the record in GW 2026 TR61. Polly Dean for the state, Blake Cooper for the defendant, who also appears in person and in custody. And Mr. Dean, you're suggesting her bond be modified and we set this over to another date?
Yes, given that she does not have any criminal history that I see. And she's from out of state, so there was a $2,500 cash or surety bond set, which she's been unable to post. She's served approximately 20-some days at this point in time. And if that insurance that's been referenced is valid, she would almost have served the entire max sentence for the count 2, which is, well, I guess that's a class B. Still, she would have served more for a first-time offender than normal. So I would not oppose that being modified to an OR bond. We set this over. She get us the insurance in advance of that hearing so we can verify it. If there's a copy of the card, even though it's blurry, if that could be, I guess she has that in her property, if that could be left with us then we can get that verified. And then I believe my understanding is should be ready to enter a fleet as no license or driving without a license and on count 2 at the next hearing.
Well, we've used March 27th. Is that enough time to get what you need?
Judge, I'd be asking for April 10.
April 10, okay.
I
Missy,
think
will
Mr.
April 10 and 10
Cooper
work?
already had some conflicts coming over, Judge.
Yeah, March 27 is going to be a difficult day for me. I'll work on that, Judge. But if we could just move this one to April 10, that would be great.
Missy, does that work? April 10th?
Yes, April 10th at 10 o'clock is fine.
Okay, Miss Allen, this is continued at the defendant's request to April 10th at 10 a.m. Your bond is being modified to 2,500 OR. That means you don't have to put any money up unless you fail to come to court. And then you're going to owe the state of Kansas, most likely, $2,500, and a warrant will issue for your arrest, and you'll go right back into custody. This is going to be by Zoom, so you have no reason to miss it, even though you may go back to another state. Make sure you get the Zoom codes from your attorney. Sounds like you may get some significant negotiations accomplished here, but you make sure you are available to your attorney and to your bondsman if you make bond. Well, you don't need a bondsman, so strike that. All right, any questions, Miss Allen, before I let you go?
One question. So does that mean the court date that I had of the 13th of next month is no longer void? It'll be this one that you just gave?
I don't know anything about the 13th of next month. Was that on a different case?
No,
we had already, I can explain that, Judge. That 13th date was moved up already to this date. So that 13th date is no longer anyway. Yeah.
Okay, thank you.
All right.
I do have one question, Blake, if you're okay with me asking this, because your client would be the one who needs to answer, but is the information that you gave me, is that on a copy of the insurance card?
Yes,
property? Because if that's
the jail has that, that's what they were reading off to me. So they should be able to drop that off at the county attorney's office.
Make sure you get that take that to the county attorney's office, which is in the same building you're in, just on the other side of the bars. Sorry. So just get that to them, or quite honestly, if a jailer could hand it through to Missy, they're at your office. However, just get that to us so we can have that verified. We'll go from there.
All right. Ms. Allen, you may go, although I have to comment, I've never seen anyone enjoy a court hearing as much as you have seemed to. Is that just because you have a comical jailer there, or is it you've laughed throughout this whole hearing? I was just curious, but you don't have to answer. You can go. Thank you.
Thank you.
I guess that's better than her shooting knives at us with her eye.
Absolutely. Absolutely. We do get plenty of that.
And then we still have Mr. Armstrong. Were we able to verify yet, Paul, or do we need to move that to April 10th?
Let me finish this journal entry and I will go check to see if they had any success in that verification. And shoot, Judge, we just appointed Albert Williams to Mr. Cooper, and we set that on that 27th date. I wonder if we just want to go ahead and move that over to the April 10th and have Missy contact him to make sure he understands that that date needed to be changed.
That would be fantastic if we could do that, and we'll verify with him as well.
Missy, could you do that?
I wonder if it'd be better if Mr. Cooper did that. Do you have his address yet, or did you not give it?
That's true.
He may not have given that to you. Well, Missy, I interrupted you there. Is that something you think you can do?
Let me see if I have his email. I could probably email him. Usually it's up to the defense attorney, I think, to contact him.
That's fine. As long as we get good information, we'll let him know.
As opposed to Miss Allen's jovial expression, I'm guessing if I could see Missy's face when I made that suggestion to her contact the driver, I might have been getting a different look. And you don't have to answer that one.
Yeah.
Well, Paul, I'm wondering on Justin Armstrong, since we don't have it verified, and he's got to do something else for you anyway. Could we do April 10 and just, and I'll talk to him real quick after the hearing, you think, or?
Yeah, because I don't see that we've gotten a response back. So that's why I say if we can get those, the earlier we can get those, the better
I
chance
know.
we have to make sure. That's all right.
Let's go on the record in Armstrong.
I
Mr.
definitely shoot for
Armstrong,
that. I'm sorry.
No, you're good.
Mr. Armstrong, start your audio and video. On the record,
ma'am.
TW 2025 TR 584, State of Kansas versus Justin Lee Armstrong, Paul E. Dean for the state, Blake Cooper for the defendant, who also appears in person. Gentlemen, it sounds like there's some negotiating going on. Announcements?
That's correct, Judge. We are attempting to verify some insurance information. There's some other talks that are still occurring between the parties. We are asking defense counsel, that is asking for a continuance to April 10, 2026 at 10 a.m. wherein I think we will have be ready to proceed at that time.
All right. I will continue this at the defendant's request. If you can make that ignition interlock, or if you can make that insurance go away, you've still got that ignition interlock matter. So, Mr. Armstrong, you make sure that you have a conversation with your attorney as soon as he's ready to address it. Make sure he knows how to get a hold of you.
Yes, ma'am.
And then make sure you come back here by Zoom again April 10th at 10, or you'll get a warrant.
Yes, ma'am.
Get him in it. If you had proof of insurance, get it to your attorney. If you didn't,
I emailed it.
Yeah,
I just emailed it while we were on the phone. I'm not very tech savvy, so it wasn't working for me very good.
I understand. I'm not either. Okay, you may go, sir. Mr. Cooper, any last word to him that you might want to give him?
Could I just have a real quick breakout room and then we'll be done?
Sure. Missy, if you would, please put them in a breakout. Justin Armstrong, Blake Cooper in a breakout room, please.
Have a good weekend, everyone.
Great weekend, Blake.
Done?
That'd be it for me.
Oh, I don't think so. Surely not. All right. I'll be darned. We did do Darlington, didn't we?
Yep, we did. Justin Armstrong.
And the last four are pro se at 11.
Yeah, a couple of them are pay or appears. Missy, do we know, have we heard anything about whether any of those that still have money paid?
Mr. Dunn paid this morning, but I still have Billups and Rhodes that haven't paid. And then that Jeffrey Gibson, I think Deputy Hanson was here for that case.
The bench trial?
Yeah.
No, sorry, Deputy Hanson, I'd sent a message to my office to, well, maybe I didn't get that done because we started another case.
You think that's
that trial matter you're here on is off at this point in time. He's applying for a diversion. He'll qualify for a diversion. It was as you know, expired tag. He has no history.
So are we continuing that to April 10th then, or when?
On Gibson, that was moved off to March 20. No, that was moved off to April 27th, I believe.
Let me see, that's what you have, April 27 at what, 11?
April 24th at 11.
April 24th at 11. Okay.
So Deputy Hanson, you're free to leave. Thank you.
And we've already.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Your name?
Mohammed Cisse.
All right. Where are we on this case?
Your Honor, I've had a chance to speak to Mr. Cisse, and we've come to an agreement. The amount of rent that's owed is $1691.88. Court costs of $175 for a total of $1866.88. Mr. Cisse said he can pay it by next Friday. Obviously, the court rule gives him through the following Monday. He signed the judgment, and so did I, and I advised him of his rights under the court rule.
Sir, is all of that correct? All right. Do you have any questions regarding anything that's contained on this, Judge? No? All right. Very good. And you were apprised of your rights under the court rule, the 3-day right of rescission?
Yes.
All right. Very good. Judgment to the plaintiff by consent, and I've signed the judgment. All right, if you need a copy, you can pick one up front at the counter. Okay, thank you. You're all set.
All right, thank you.
Thank you. Sandy McFiddish versus Donovan Alexander.
Good afternoon, Your Honor. David Fantair on behalf of the plaintiff.
Your name?
Alexander.
All right.
Your Honor, I spoke to Mr. Alexander and we've come to an agreement. The amount of rent that's owed is $2,310. Court costs of $175 for a total of $2,485. Mr. Alexander says he can pay that by next Wednesday, which will be the 4th. So obviously I'm going to give him till the 9th. We both signed the judgment and I advised him his rights under the court rule.
Sir, is all of that correct?
Yes, Your Honor.
Do you have any questions regarding anything to think of this?
No.
And you did receive your right of rescission today?
Yes, Your Honor.
All right. Well, court will enter that judgment by consent. All right, if you need a copy, you can pick it up at the front counter. All right, have a good weekend.
Thank you.
103 South Hira versus Joshua Bertram.
Good afternoon, Your Honor. David Fantair on behalf of the plaintiff.
Your name?
Joshua Bertram.
Thank you.
See you, Judge.
Good seeing you, sir.
We come to an agreement on this one also. The amount of rent that's owed is $245, court costs of $175 for a total of $420. Mr. Bertram says he can pay that by Monday. I gave him obviously till the 9th. And I was thinking that because the amount is relatively low, we should put under further orders, no writ without a hearing. Have I caught on now?
Yes, you
finally.
All right.
So what that means is that if for some reason you don't pay, and if I file an order of eviction, the court would set that for a hearing. So
Yeah, may I say something?
Certainly.
I get paid basically twice a month.
Okay.
And it's been we're in our slow season right now. So my check has not been like half of what it used to be. So I'm just trying to make do with what I can, and that's how I fell behind. So I do apologize. I don't mean to be back in here.
Well, it's okay. You know, quite frankly, young man, that happens to a lot of folks. And I think what's fortunate about being in this county is that a lot of the attorneys, a lot of the judges appreciate that's what happens to people. And it's really just a matter of catching up, getting yourself kind of a little bit ahead so that happens.
I'm trying my hardest, sir.
No, I got you. So your slow season, when will it pick up? Like April?
I think March, April.
Okay.
When March Madness starts to begin. I work for a printing company, Underground Printing. So after like Amazon orders are done with through December, like the end of December, we start slowing down through July, February, and March.
Got it.
And then once the school season starts again,
then you
start back up work. So
do they order any like Maryland gear to print?
Maryland?
Don't say confused.
Just say yes.
Don't look confused.
Yes. Yeah. No, we print we print all of them. Yes.
Anything with it.
What'd you tell him? Just say yes. Just say yes.
University of Michigan, MSU, we do Iowa.
MSU. That's like Spartans.
Yeah, that is.
Yeah.
We do everything.
That'd be easy to print. Anyway.
You guys want
All right. Okay, sir. So you have no questions on this judgment. I'm going to enter the judgment by consent. All right. And so if it doesn't pick up right away and you're back, you're back. We'll get you through it. Okay.
I dealt with Mr. Bertram before. He's always easy to deal with and we always work something out.
Yeah. And it's just getting there. So
just getting there.
Just getting there. All right. You take care of yourself, young man.
Thank you.
All right.
Thank you, Mr. Bertram.
Where? Why?
Because she was
Lacey's in Zoom. Why is she in Zoom? Oh, she's someplace else. What? She said she's not coming here to see me. She wouldn't make it in time.
We did start at 12.
Did she know she didn't? She knew she had 12. Why?
That's a question.
Where is she? Do you know where she is?
Detroit.
Did she tell? She's in Detroit?
Yeah.
That's a big place.
It is a big.
That's all for me at 12. I'm
You're
covering
gonna come cover at 1,
yeah,
right?
for Sydney. Yes.
Okay. All right.
So I'll see you in an hour. Thank you.
All right. Thank you, sir. Arbor Meadows versus Akio Fujimaki.
Good afternoon, Your Honor. Gabriel ACP 79685 for the plaintiff, Arbor Meadows.
Did you hear us talking about you?
Yes, Your Honor, and I do appreciate you allowing me to appear via Zoom.
You're more than welcome. All right, Mr. Stringer.
Yes, Thomas Stringer appearing on behalf of Akio Fujimaki.
All right. I have a dismissal.
So, Your Honor, if you could allow me this time to address Brother Counsel, I had a family emergency, and I do apologize. I did not get to reach out to you and let you know that we were dismissing this case. And we will not be bringing up the other cases.
You have any objection to that?
Well, I have no objection to it being dismissed. My client did want me to ask for fees. You reserved them. I've had to come back again. When I look at I looked at my time after today, I'll have between $1,200 and $1,500 into this. It's unfortunate that my client gets charged for that.
Do I have permission to sign your name?
Yeah, I will say
Have
that.
anything to say to that?
Yes, Your Honor. I will state that this could have been resolved if he had just paid the court costs with notice. And my client was willing to do that and waive the late fee. I was willing to be very amenable, and at this point, decided to just do a courtesy fee waiver for the court cost. Right. And I do not believe that fees should be attributed to my client, as my client's just trying to assert their rights as a property owner and keep the place where he calls home beautiful.
Yeah, but remind me, were the court fees due?
There were court fees, but the issue was Your Honor did not specifically award them in the last case. That's what it was.
Right, but that's part of the problem. And Ms. Lacy, I appreciate that you at Emergency Counsel has been out here twice, and I was extremely skeptical of the argument that was being made at the last hearing, because everything was settled. And quite frankly, I don't know that Arbor Meadows should have been coming after him for something that wasn't contained in the written agreement or judgment between the parties. And that was part of my problem. And now we are back here again. And
I appreciate counsel having some family issue, but somebody from the firm could have sent me a dismissal, or at least I wouldn't have had to come out here today. And that's what's inherently wrong about this. And I'm not blaming counsel, but obviously she works for a firm who decided to file this. And really, there was no merit to filing this. And saying that Mr. Fujimaki could have paid the fees, well, he wasn't ordered to pay the fees, and we never agreed to pay the fees. So this is just wrong. I'll leave this up to the court.
And Ms. Lacy, I get the family emergency, I get all of that, and you kept the court apprised that you weren't going to be able to be here today. I wasn't sure what was happening on the case. So that I'm not I think all of us that have been in practice realize stuff happens, right? Okay, so I get that. I appreciate though what Mr. Stringer is saying, that somebody could have sent that. I am also, how do I want to say this? I'll put it this way. Sometimes people are sent in to give arguments that may themselves not have a whole lot of merit. And they have to just go about doing their job. And I can appreciate that. And I don't fault attorneys when they're placed in that position. I may be wrong, but I think, Ms. Lacy, you always give very good, cogent arguments grounded legally before this court. I felt, well, I'm just going to say it, and I don't know if I'm right, but I think that if it were up to you, we wouldn't have been here last time arguing. I think somebody has put you in that position, and unfairly so. I say what I think. I think you were put in that position unfairly. I don't think you would have given me that argument because that's not what you do. But Mr. Stringer and his client should also not be. So I'm not going to award the $1,500 or whatever it would be, the 15 to 20. I will award $500 in attorney fees that will need to be paid by, I'm going to say is that it needs to be paid by the plaintiff to the defendant's attorney.
We have a time frame, Your Honor? 2 weeks, a month?
Yeah.
Whatever the
pay it by March 16th, 2026. All right.
And I just want to put something on the record that I've had my assistant check every day for the last few days to see if we were receiving anything.
Right.
Because originally she was going to, and I'm just not blaming her, going to file a brief or file an amendment to request an amendment. So there was just nothing ever, and the dismissal could have come. I mean, from somebody.
And I'll say this, and I'm not here to defend Miss Lacy. I'll just say this. If she could have, she would have. I have no doubt in my mind. And I think that there may have been outside things hampering her. So I don't hold her responsible. That's why I phrased it the way that I do. I don't think that comes, I don't know whose pocket it comes out of. I'll make this clear in my mind, it should not come out of Miss Lacy's pocket. Whoever did what they did, that's who should be paying. Because I don't think she would have done this. She's never done that in the years that she's been practicing.
I fully accept that. I have no ill will at all.
I know you don't. So, and it's a good thing that this is the attorney on the other side, because this could have gotten real ugly. So, all right.
Probably true.
Yes. Thank you.
Thank you.
And Ms. Lacy, I'll say this. Mr. Stringer doesn't come out here that often. He used to come see me all the time. Now it's every once in a while, here or there. So the very fact that it didn't get to him and I got to see him again, I'm okay with it.
Mr. Stringer, my sincerest apologies, and I do thank you, Your Honor.
Well, and I appreciate that. And again, there's no ill will whatsoever. I think you're a fine attorney. It's just things happen.
Things happen. All right. Thank you.
Thank you.
$600.
500.
No. $600 from our Meadows to requested me is sharing gone. $600 is.
That's in the other case.
That is stated.
Oh, yeah, no. This case is being dismissed.
This case is being dismissed.
That's what he's asking about, the $600 that they requested.
Yeah.
Absolutely.
All right. Thank you.
Thank you, Aaron.
Field Properties versus Matata Patrick.
Gabriel Lacy for Bill Properties.
Not checked in.
They have not checked in. Would you like to take a default?
I would, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
At this time, Your Honor, we are requesting a default judgment for possession only, where the outstanding balance to pay is $1,918.36, court cost of $175, Total balance owed is $2,093.36. We are asking for a pay or vacate date of March 9th, 2026. And I do attest to the best of my knowledge and belief that the defendant is over the age of 18, competent adult, not deployed on active duty in the military. We have kept the unit fit for habitability.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested. The writ to issue 10 days. All right.
Thank you so
Thank
much,
you.
Your Honor. Have a wonderful
Thank
afternoon.
you.
Thank you to you and your staff.
You have a good weekend.
Thank you.
14A stands in recess. I can reach it. Who are you? You my next lot?
Yep.
Okay.